I approach the government for some permission to sell those, and there is some royalty distribution. So there's some
We need some time to dig instruction.
Mr. R.R. Gogoi, Learned Counsel for the Forest Department, is given last chance
Yes, Lord.
to file affidavit. Release the matter. After Bihu?
After Bihu, some date may be fixed. Lord.
Give a date.
May I plead for listing of a motion matter from 16 or 17 months? I filed it on 10th.
Okay, 17th?
Public.
Okay, heard Mr.
Yes, Rabha.
S. Rabal, Learned Counsel for the petitioner, who submits that the order dated 12/6/2024 passed in WPC 5889 of 2022 for payment of the petitioner's contractual dues has not been paid. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice within 3 days. List the matter after 4 weeks.
My lord, there is an analogous matter where notice has been issued. That matter might be tagged along with this matter.
List this matter along with
Contempt case number 660 of 2024.
660 of 2024
Four.
on the
Okay.
next day.
See the last order dated 2/12/2024.
Give him a copy also.
The earlier direction was to examine the claim of the petitioner, my lord. That exercise has been done, my lords. The claim, the amount that is payable to the petitioner, my lord, we'll see at page 2. After deductions, my lord.
Payable by the petitioner or payable to the petitioner?
To the petitioner.
To the petitioner.
Making the necessary deductions, my lord.
4,65,000.
Yes.
So you pay this amount, end of the matter. Yes. If you are not happy with this, then you go to civil court. Okay, right. Heard Mr. A, the Learned Counsel for the petitioner, who submits that in view of the letter number so it's out here. Letter number so okay, dated 12/12/2024, issued by the Chief General Manager (Com and E (APDCL) and the final settlement of accounts, which has been annexed to the said letter, wherein the APDCL has admitted to the outstanding liability payable to the petitioner amounting to rupees 4,65,633. The writ petition can be closed. He, however, prays for liberty to approach an appropriate forum if the amount is not as per the his statement of accounts. Mr. R.R. Gogoi appearing for the
Chaudhary.
Mr. B. Chaudhary appearing for the APDCL. Submit that he has got no objection to the submission made by the counsel for the petitioner. Accordingly, in view of the letter number so and so and the final settlement of accounts annexed to the said letter, the writ petition stands closed. With liberty being given to the petitioner to approach the appropriate forum if he is not satisfied with the amount, with the admitted amount made by admitted amount. Stop. The letter dated 12/12/2024 issued by the Chief General Manager is made a part of the record and marked as an Annexure X.
But the payment may be made within a period of.
The outstanding dues payable by the APDCL to the petitioner should be paid at the earliest and not later than 1 month from the date of receipt of a copy of this.
I'm deeply obliged.
This matter, they have in the meantime floated a tender. We have filed an IA with a very limited prayer. So we may be allowed to participate subject to the outcome of the writ.
That will amount to giving them the final relief because
No, it is-
They are blacklisted.
they are blacklisted.
Black-
And
Blacklisting is under challenge. What they have done is, in the meantime, they have floated a tender. We are saying that it will be subject to the outcome. Because if the blacklisting is upheld by this honorable court, I will automatically have to go.
they are allowed to participate while they are undergoing that blacklisting order. That
Well,
amount to giving them the final relief. Pursuant to
There's
your
no stay
lordship's-
order passed. Huh?
pursuant to your lordship's direction of 25th of November, we were directed to consider the representation. Because their prayers are threefold for release of their dues also, apart from the forfeiture of the bank guarantee and the blacklisting. So regarding the release of their dues, your lordship, that part the department is corporation is willing to consider. And on the consignments which have been successfully delivered by them, those amounts will be paid.
The consignment that has been.
Successfully delivered by them, that those amounts will be paid. So
Except for the lost consignment.
except for the lost consignments, sir.
So that is going to be recovered from them.
Because though that amount, your lordship, it's almost 26 lakhs odd, your lordship. That amount has to be.
That we have already said in the representation that in any case, we are not privy to what order has been passed. It has not been served on us.
Which, this one.
I'm giving them a copy.
Twenty-eight lakhs, not 26. 28 lakhs, 85,000.
28 lakhs.
That is one of the grounds taken in the reputation. In two different order, two different figures are mentioned. What is the basis of the calculation? That also has not been given to us.
Anyway, the fact remains that a certain amount was lost.
Yes,
Maybe the
That-
figures
yeah.
are not correct, but it is above 20 lakhs.
and my lord, we are the ones who lost the FIR. We are the ones who informed them. It is on that basis they issued us the.
But
super-
you lost the FIR after 1.5 months.
Because there were two trucks involved. Almost 15 days apart, there were two trucks involved. When the second truck also failed to reach, that's when we made our inquiry and we found that the driver concerned is playing around with us. That is when we lost the FIR, and on the same day we intimated them.
But aren't you responsible for the
That
actions of your
responsibility
driver?
under the contract, my lord, I cannot shirk. That is certainly, we are not shirking. If your lordship has a look at the representation that we have made, we are not saying that you do not recover it from. We are just saying that because if they adjust it against our dues, outstanding dues, what happens is the GST also comes into play. We are saying that we will instead give you the amount separately. That way also you recover.
Okay, so you do not mind giving back the lost amount.
Yes, but don't deduct it because we have paid the GST also in the meantime. That also gets affects us prejudicially.
So they want it both ways basically now.
But they want to recover 25 lakhs, assuming hypothetically 25 lakhs. We are saying we'll give you that 25 lakhs separately. Don't recover it
When
from the
can you give it?
When can we? No, it's any day. By Monday, Tuesday.
So if they are willing to, if they are saying that, you see, this is the fault of the driver.
No.
And they are willing to make good the loss.
Not sure.
Let them participate.
Not should be
Subject
concerned.
to the outcome.
The concern is that the books that they are delivering, your lordship, apart from the financial aspect of the matter,
Yes, yes.
those are textbooks meant to be delivered within, because time is of the essence.
That is gone now.
Yes.
Forget it.
Yes, sir.
They're gone, they're gone. You cannot, if it's like you give a young boy a sweet, he eats it, and then you say, no, give it back to me. How is he going to give it back to you? Maybe in another form, that's all.
Yes, sir.
That original form is lost.
Yes.
So here also, we do not know how they're going to give it back to you, but it will not be in the original form.
The whole issue is, the reason we submitted the representation was, the investigation is going on and there's a possibility of recovery.
So what you can do is you can talk to your client, maybe.
Yes, your lordship.
Talk to your client, we'll take it up at 2.
Lordship.
Try to see if they are agreeable to, see if they are agreeable to do it today. Or by tomorrow, we'll fix it on Monday. And let it participate.
Lordship, then let them, if they can give me a specific date by which.
No, they said today.
By
No. By Monday we can.
By tomorrow? Huh? Okay, they said by tomorrow or by Monday.
Very
So
well.
you just tell your client,
I'll get that instruction.
once they agree, then we can close this matter. Actually, all those things will do, because your basic problem is that consignment has been lost.
Not sure.
Now they are saying that we will make good the loss
Not sure.
and let the criminal case take its own
Not
course.
sure.
Okay. And with regard to the blacklisting, that if they're going to make good the loss, why should it remain?
Yes.
So you just talk to them.
Very well. I'll
Where,
get that.
2 o'clock or
On Monday, Your Lordship, I'll get that.
Monday? Okay, right. Mr. K,
Your Lordship may have it at 2 rather.
at 2.
Very well, Your Lordship.
At
Because
Only thing is, I have to rush somewhere. My friend will be there.
No problem. If you are not there, adverse order might be passed, but if you want to take the risk, they've hired a senior counsel. If senior counsel is not there, then all the mice can, start to play.
That
music.
much confidence I have, my lord. Both on the court and on my friend.
So all of us will have now confidence to say a bit more, what in his absence.
Or it might work the other way around. My absence might
Might
gain
be
some
conducive.
sympathy, extra sympathy.
Might. Anyway, at 2 o'clock. Okay. He's not here. What to do? Shall we wait for some time? Or you want to do it in her absence? Take advantage of her absence. What do you want? I leave it entirely up to you. Whether you want to take advantage of her absence or you want to wait for her.
Till how much time?
Huh?
Your lordship, when are you going to take it again?
No, today only. Today. I'm just thinking. I leave it up to you. You want to take advantage of her absence or you want to do it?
I'll wait for some time.
After some time.
Affidavit.
Correct, that's fine. Yes. Have you got the instructions?
Yes. Before that, my lord, I just want to point out some more points. From the writ petition, my lord. Page 31, my lord.
Page 31.
31 first,
Yes.
my lord. Yes, page 31, serial number 12.
Yes.
Married lifting period. The successful buyer shall lift the material by employing their own labor and
Within 30
transport.
days.
Within 30 days. Then my lord may kindly have a look, page 44. Page 44. This is the delivery order issued from the MSTC to the petitioner. It is on 5/9/2023 for lifting the vessel, my lord. But after that, they have prayed before the IWT director to extension of their time. And this extension was granted. Now, my lord may kindly have
Where's the prayer? Where's the prayer? Page?
page, lordship, annexer 6, page.
No, that's page 44. That page 44 is the lifting
Yes,
delivery.
46, my lord,
That
46.
is the delivery order.
Yes, and then page 46, annexer 7. Annexer 7.
Uh, I think, can you tell someone to buy strepsils? I think,
I'm so sorry.
problem. I'll just give you the money. Okay, sir.
On 11/9/2023, they have written to the Joint Director for extension of lifting period. This is the petitioner Om International. They have written for extension of lifting period. The Lordship may kindly have a look the annexes bus I have given to my Lord. The letters, 3 letters I have produced before my lord. So letter dated, first letter, this letter dated 29/2023. It is written by the director to the petitioner Om International regarding extension of lifting order. With reference to the letter and subject cited above, I would like to inform you that as per your request by letter dated 11/9/23, this directorate has extended the period as mentioned in the lifting order of the next 2 months up to 30/11/23 against the lot number 2, 3, and 5 as mentioned in your letter. Lordship, the next letter, my lord, next page. It's letter dated 14/11/2023. It's written by the director to the junior engineer NK Ferry Service for handing over of condemned vessels lying at your disposition. Deliver at a number so and so. The lordship, it was copy forwarded for
Just a minute, madam.
Lordship.
The first letter is signed by Hanif Nurani
Yes, he's a director, my lord.
to the Home
This is
International.
the petitioner. Now we have on their request, we have extension the lifting time. Though it should be lifted within 30 days as per the NIT condition, but we have as per their request, we have extended the time. And the second letter, my lord, is written by the director to the junior engineer. Subject handing over of condemned vessel lying at your disposition. Sir, with reference above, I would like to inform you that Om International Guwahati 9 has deposited the bid value amounting to rupees 8 lakhs, so and so, lying under your disposition. You are thereby requested to hand over the unserviceable above mentioned vessel to Om International in as and where is condition and submit the handing over, taking over charge. It is copied to the serial number 4, Om International Guwahati 9. They are requested to contact with concerned JE NK Ferry Service for taking over the condemned vessels in as is where is condition, my lord. We have written to them, but they did not lift it. Now, as per my and the other letter, it is there impugned here in the repetition that we have written to them to lift their vehicle, and since we have already extended their time period, but as per my pairwise comments that I have forwarded to my lord, it was written at present this vessel is under submerged in water,
Okay.
but no fault from our side also.
Ah,
This is my submission. Lordship may pass appropriate order, or my lord may grant me some time to bring it on record, my lord.
no, so can they take it?
It is still underwater. The lordship, instead of keeping this matter pending, my submission before my lord is that lordship may directed both the parties, the petitioner and the one of the official from the directorate, to visit the site, visit the vessel physically. If it is possible, they can lift it. If it is not possible, then directorate may have to take steps to refund their money. This is my submission. Though fault is on their part, but I
Correct,
can't say
correct.
we will not refund their money. But physical verification should be there.
What is the terms of agreement? Is there any terms of agreement?
No, it was the e-auction was conducted by.
Yes, so you tell me, you did not take the vessel. In time.
I'll come to the point. The facts are like this, your lordship. MSTC is the authority who conducts the auction. After the bid monies are deposited,
Who is the authority?
MSTC, the third party, my lord.
let me
Metal
make my
Stamp-
submission.
Huh?
Metal State Trading Corporation, your lordship. They are the authority who conducts the auctions.
Okay.
So I have to deposit the money in their account. So once the deposit amount has been deposited, they'll issue me the delivery letter to which my learned friend is referring to. After that, I have to go to the director IWT,
Director?
IWT, Inland Water Transport, because it is at their disposal. And thereafter, the director will issue me with the delivery order. With that delivery order, I'll go to the place where the vessels is located. And the concerned junior engineer or the assistant engineer, whoever is there in charge of that area, will hand over me the vessels and give me a report.
Handover means just
Yes.
take it, that's
Take
all.
it.
Take it.
He's not
Take
going to.
Naturally, your lordship, I have to take my infrastructure and manpower, I have to cut it and bring it. But when I went there, the vessel was not there, your lordship. That's my entire case.
Vessel was not there because it was submerged. It was there, but it was underneath the water.
That's what your lordship.
Then
No.
it is there.
Yes, it is.
It is there. It is there. It's only underneath the water. So you have got to go with your scuba gear. Go with your scuba gear. Get all those gas cutters which work underwater and do your job. You cannot sit over on top of the ship with your breakfast and tell your workers, cut that, cut that, cut that. You've got to go with your scuba gear and do it. That is your problem. You know, you don't want to do
The
that.
Vessel was at the bank of the river. When I inspected it, your lordship will kindly annex.
Mr. Council, they're saying it's underwater. So you go and see what is there. It's not that it's disappeared.
It's disappeared from the side. Your lordship will
It,
kindly. see
it
page
disappeared from the
62.
side.
Your lordship will kindly see page 62 for a moment. I'll go by down whatever your lordship passes an order. But
You have to, you've got
Yes,
no
your
choice.
lordship.
But then you see, you've
But
got
I
to, you've got to understand,
Yes, your lordship.
a vessel like that cannot disappear just like that. When they say it is there, it is underwater. Have you gone underwater and seen it?
Your lordship.
Have you had someone jump into the water and seen it under the water or not? You have
It's
not
a
gone.
big vessel, your lordship.
It's a
not
big
small
vessel. So you cannot miss it. Even you go jump into the river, then you'll find it there.
Your lordship, I'll just point out one thing. Your lordship will kindly see page 62 and 63.
Yes.
These are the photographs taken on 12/10/2023.
Correct.
So on 12/10/2023, the junior engineer said that the vessel's position is reflecting in page 63. It's not there. Page 63,
Yeah, yeah.
right? 12/10/2023. And now your lordship will come to page 49.
Yes.
This is 14/11/2023.
Yes.
So the vessel was untraceable on 12/10/2023 itself. And they issue me the delivery letter on 14/11/2023, your lordship.
Delivery is well, page 44.
Look, I'll just show you
Yes.
these letters here. There is a letter of
Maybe I missed-
14 November, of 14 November. You're talking about 14 November. There's another 14 there. The same letter. Anyway, the fact of the matter is, cut a long story short, I know these are disputed questions of fact, according to you. So you go and see if the vessel is there. If the vessel is there, take it. That's all. Nothing remains.
In the case the vessel is not traceable, your lordship, they can refund my money, your lordship.
If depending if the vessel is there or not. If it's there and you don't want to take it, that's a different thing.
Yes, your lordship.
We do not know.
I want to take it, your lordship. I want to take
So
it.
let
I'm a
the-
small time businessman.
Let the director and you
Petitioner.
jointly go and verify.
Yes,
Yes,
my
your
lord.
lordship. Your lordship will keep the matter till then. We'll come and report before your
No,
lordship.
no need. Why should I?
Your lordship have to come back again, your
Why?
lordship, if it's not there.
Why?
Because suppose tomorrow the vessels is not there,
Uh,
then they'll again keep my file pending. I have
Okay.
to come down again.
Okay.
Your lordship,
Lordship may kindly observe this one.
your
You need
lordship
to
will,
keep this
your
matter
lordship
pending.
will keep the matter pending till Thursday. We'll go
Thursday.
tomorrow only itself. Tomorrow itself will go. On Thursday we'll report it. I'm making a fair submission to that effect, your lordship.
Well, let them, you all go tomorrow. Tomorrow tell them to go.
Will they put one of our
It's at
officers?
remark-
Your officer will go
Yes, lordship.
and your representative will go.
This
And-
petitioner will go.
But tomorrow is Saturday. They can still work, I think. Then
Yes,
Tuesday we'll dispose of the matter.
lordship.
Tuesday, your lordship will not keep. Let us.
No. You cannot have everything as
Let
you
it
want.
be on Thursday, your lordship.
No. Sorry. Right. And Mr. R. Singha, learned counsel for the petitioners. And Ms. M.D. Bora.
Huh?
Learned counsel for the
Transport Department.
transport department. Full stop.
Your lordship.
The,
I'll just, sorry to interrupt your lordship. Tuesday, I have some personal inconvenience. Let it be on Wednesday or Thursday.
okay, Wednesday. Miss M.D. Bora, no, Miss M.D. Bora submits that the vessel is underwater.
Sure.
But it is underwater and the petitioner can take delivery of the same. She also submits that the delivery of the vessel had not been taken by the petitioner, as the petitioner had asked for extension of time to take delivery of the same. Full stop. Next, Mr. R. Singha submits that the vessel is not there in the water, as per the photographs in the writ petition. Full stop. Next paragraph. As to whether the vessel that is to be that is to be delivered is lying in the river, underwater or otherwise, would have to be verified by the Director of Inland Waterways,
Transport,
Transport Department,
water transport.
Inland, Director of
Water
Inland Water Transport, and the petitioner. Accordingly, the Director, Inland Water Transport, and the petitioner or their representatives
Sure.
should have a spot verification done tomorrow. That is, what is it? What is the date? 14th, 14th, 2024. And make a report.
Sure.
Make a joint or individual, make a joint report. Make a joint report, which should be produced before this court on Wednesday.
One submission which my learned friend made that I was asked to pick up and I could not pick up. That's not a correct proposition of facts.
That's her submission.
But the
She can submit
report was
anything.
only on 14th/11, they have issued me the delivery order that direct.
Lordship, I am submitting from his writ petition, page 44.
And I've annexed all the documents.
Next,
Page
Deeply
44. I am
appreciated.
submitting from your writ petition only.
this is the
Obliged,
matter on
madam.
Wednesday.
Obliged, madam.
Acha, one before that. The petitioner shall, where should they meet? But where?
I'll go to the director office today
The
itself.
petitioner shall, for the purpose of the spot verification, the petitioner shall go to the director's office
Like today itself.
at, by 3 p.m.
Okay.
today. So that a fixed time can be fixed for the spot verification tomorrow.
Obliged, madam. Deeply obliged.
Your lordship may add to that, that if the vehicle is not fit to be lifted or if the vehicle is not traceable, in that case, they'll refund the quit money. Your lordship.
That we
Then
will
when
see.
is the lordship
Let
of
us
this
see.
order?
Your lordship.
Obliged.
Desilting, madam.
Lordship.
Desilting. Okay, your name is
Special.
S. Baisha. For the petitioner. And Miss,
Lordship, Mr. Esbara's name may be recorded.
okay, Mr. S. Bora for all the respondents, Then out here, the first thing is invitation for bids the same date, madam,
Lordship?
same date.
Yes.
Then what is the letter of acceptance dated?
4/5/21.
Right, letter of acceptance 4/5/21. Contract price,
82,08,794 and 70 paisa.
have you got it? Once more, slowly.
82,08,794 and 70 paisa.
Okay, then notice to proceed with work dated
11/5/21.
11/5. 11/5/20. Okay, that is it. Okay, then a reply dated. Acha, wait, see the package number?
11.
Package number 11?
CND 11.
CND 11. So package number CND/11. Then show cause notice dated
8/6/21.
8/6/21. Then reply dated
11/6/21.
11/6/21. Others are all the same.
Lordship.
So you take it that WPC 1622 of 2024. 1622 of 2024.
Which is your lordship? My lord, legal years of a contractor has come for my lord, the undisputed bill amount. But this is the second round of litigation. Earlier, there was a direction to pay within a certain period of time that was not complied with. The contempt was filed, my lord, on assurance it was withdrawn and part payment was made. At this stage, your lordship will issue notice.
How much how much is still to be paid?
My lord, 40 lakhs and 50,000
How much?
40 lakhs,
15,000.
50,000,
50,000.
50,921.
4 14, comma,
4050-321.
4050
921.
921. And the earlier WPC was 19.
My lord, yes, earlier WPC was disposed of.
Four
on my
three
lord-
two three 4329.
Yes, on my lord, 4329 on
27.9.
yes.
There's a contempt also.
Contempt was, my lord, withdrawn because there was assurance and thereafter some payment was made. Now at this stage, I pray for a notice, my.
No. How was the contempt closed? Let me see.
No, contempt was closed because it was withdrawn, my lord.
We don't why.
Because, my lord, we were given assurance, that's why, my lord, it was withdrawn.
Here also, they have not made Ministry of Jal Shakti as party. Lordship, notice may be issued.
They've not made Ministry of Jal Shakti party.
Yes, sir.
Brahmaputra board also not made a party. It's the same work.
Yes, Your Lordship, but still we need to obtain instructions.
No, but then
Not
again you're going to take the plea that they are not parties again.
Actually, we have not received the instructions.
Yeah,
Regarding
I think what you should do is you should add the Ministry of Jal Shakti and the Brahmaputra board as a party. Because they're going to take that plea later on anyway.
Yes.
You see, and a lot of contempt petitions are pending because they did not make these two a party. And they are the ones who are to supply 90% of the funds.
But the
And
contract,
the Brahmaputra board is the one who has got to verify and is the link between the state government and the ministry.
but the, my lord, NIT was issued by the Water Resource Department.
Huh?
NIT was issued by the water.
Correct. But then the funds are 90-10. 10 is by the state, 90 is by the center.
But they have not, never taken a plea that, my lord, the fund was.
And then now they're starting to take. Now you see, I've got there are many orders passed before, before I was touching this bench. And those are all now in contempt. And they're stuck in contempt. They're giving some money here and there. Now, in one or two, they have started putting the Jal Shakti and Brahmaputra board apart. Because Brahmaputra board is the nodal body between these two.
Wait a minute.
So I think maybe,
Then we'll file an application for treatment, my lord. I think.
Yes.
no, why don't you withdraw this and file afresh?
That can be altered.
Where that'll become, you have to file, then again repeat, and you've got to change a little bit here and there.
Because, my lord, they have taken this ground, that's why, my lord, we withdraw and, my lord, file it.
Yes, because of that.
Fine.
Lord Mr. M.K. Chaudhary, the senior counsel, who submits that the petitioner had been given various work orders, various or one,
And one.
had been given a work order by the Water Resource Division. Water Resource Department. Which had been duly completed by the petitioner.
Within time.
However, as the contractual dues of the petitioner were not being paid, the petitioner filed WPC 4329 of 2019, which was disposed of by an order dated 27/9/22,
2022. 27/9.
with a direction
Total
to the
period-
respondents
Total period of, my lord, the 60
To-
was page 36, my lord.
to
Page 36 is the direction.
make a verification and complete the process for payment of the admitted amount. Full stop. Subsequent to the above order, thus in WPC 4329/2019, the petitioner filed contempt case bracket C 45 of 2024 due to non-compliance with the direction passed in WPC 4329 of 2019. Full stop. The contempt petition was, however,
Withdrawn.
withdrawn with liberty to file afresh by the order dated 22/1/2020. Next paragraph. The petitioner's counsel submits that though part payment has been made, the petitioner is still to receive an amount of 40,50,921. Next, Ms. D. Jane, appearing for the Water Resource Department, submits that the funds for the scheme for which the petitioner had worked is funded by the central government and the state government on a 90-10 ratio.
For your lordship, it's 80s to 10, 80s to 20.
18 to 20.
Yes, sir.
18 to 20 ratio. But earlier one we did was 19-10.
Yes, your lordship. This share is divided according to the schemes.
Okay, according to
Yeah.
what have I said? (80-20) basis. First one. She submits that the Brahmaputra board is the she submits that the Brahmaputra board also has a major role to play as it verifies the work done by the petitioner and is a conduit, CONDUIT, conduit between the Water Resource Department and the Ministry of Jal Shakti. She accordingly submits that the Ministry of Jal Shakti and the Brahmaputra board have to be made parties to the referendum. Next paragraph. Mr. M.K. Chaudhary, learned senior counsel, submits that in view of the submission made by Ms. D.J., learned counsel for the Water Resources Department, he would like to withdraw the writ petition with liberty to file a claim. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, comma, with liberty of paper.
Oblige, sir.
The petitioner executed a contract work, transportation and handling with FCI. He has completed the work. The work was transportation of goods from railway siding to FCI go down. Now, there was delay in clearing the goods from railway siding. So under their guidelines, they imposed demurrage cost. My lord. The only issue here is, my lord, in all the cases, railway has imposed 6 times demurrage. That is the maximum penalty. That
So-
they cannot do under their own circular, my lord.
Why can't they do?
In a routine manner, they cannot do the guidelines.
How do we know it's routine or not?
But in every case, it has been given, my lord. In every cases, but not a single, all the cases 6 times, my lord. That they have been doing it, so that has been,
So how much should it be? 5 times?
my lord.
Should it be 5 times?
No, my lord, they have to be reasonable. That guideline has been given in the railway circular, my lord, and
How much is the amount payable by you?
2.5 crore has been deducted, my lord.
So,
So, and that is the thing, my lord.
any alternative remedy available?
No,
Lordship, in this case, he himself admitted paragraph 18. It is that we have
Paragraph?
we have direct relation with the FCI only. He admits that he doesn't have any direct relation with us because the contract is given by the FCI. So FCI, we have deducted from the FCI. Now FCI turn is to deduct from him.
yes, the FCI is the middle,
So
middle position, my
And
lord.
FCI has already rejected his claim and that has not been challenged.
No, FCI, matter what railway has
Page-
done, FCI has
Annexure
deducted.
15, Lordship.
Page?
Page 114. Already his claim has been rejected by the FCI.
No.
That ought to be challenged, Lordship.
FCI basically says that railway has deducted, so we can't do anything.
So so this order, page 114, what does it say at the end? Let us read.
Conclusion, Lordship. Page,
Which page, my lord?
Ends at 119.
conclusion 118.
118.
GFC order. They said that already 19 lakhs has been waived. So that much.
So the principal respondent will be the FCI.
No,
Not we, Lord.
my lord, how, it proof,
He himself, let me say paragraph 18 that he has done, does not have direct relation with us.
no, page 53 may be seen, my lord.
Let us see what you have said in para 18.
Para 18.
Page 12.
No direct relation with the railway.
Yes, my lord. My lord, but that guideline says, page 53, Lordship, can you see?
No. So,
Both consignor and the consignee can come up against demurrage, my lord.
So he is neither consignee nor consignor.
I'm consignor.
No, he is only handling agent. It's the FCI. He is only handling agent.
My lord,
so have you put this order dated 6/6/24 to challenge?
no, GSC order I have not challenged, my lord. GSC order I have not challenged because of the reason I said, my lord, that FCI, my lord, only has taken from me, from my bill, what has been deducted by railway.
So you see, why are you fighting FCI's battle?
I'm not fighting with FCI, my lord.
No, but you should. They have taken it from your bill and given it to railways.
No. Lord. System is, my lord, whenever there is demurrage charge, they deduct it from FCI, not from me. And FCI,
And FCI has deducted it from you.
From me, my lord.
Then
So FCI has nothing to do. Whatever
Paragraph 11.
deducted by,
Paragraph 11.
it's like this. Supposing I owe something, you owe something to me, and I owe something to him. He takes the money from me. Because I've got relationship. Then to cover that, I have taken the money from you. So won't you file a case against me?
no, my lord. FCI have not done anything on their own, my lord. Whatever has been deducted by railway, that 6 times and all, they are just deducted from my bill. That is their stand also in the GFC also. So that's why, my lord, my grievance is against railways that why, my lord, this 6 times, and notice here more when that may come up with a reply, my lord. Paying for a notice at this stage only. But FCI cannot give me the relief, my lord. FCI's stand is that it is being deducted by railway. And I have taken the matter with FCIs and railways. They are not, actually, I am taking the whole, my lord, the impact of this deduction. FCI is not supporting any money.
No. It's okay that you are fighting railways, but you should fight the FCI also. They are the ones who deducted your money. Because
FCI has been, my lord, they are performer respondent in this case. They are performer respondent because they are necessary.
and they are the ones who have rejected your
Rejected-
representation.
Rejected on the basis that railway has deducted it.
Correct.
Right.
But then you have got to challenge that also.
Their and my lord, my submission is this. My lord, their action, what I understand, my lord, FCI had no option but to deduct it from my bill. FCI has not done anything against me. They are saying that it was deducted by railway, so I am deducted from your bill. FCI on their own. would
Okay,
not done
show me that 6 times. Where is that?
6 times. my
It
lord,
should not be done in a routine
my
manner.
lord,
you
my
think.
lord, my lord.
The
That,
demurrage charges.
page 40, the compendium of railway matters, and also there is another. Well, page 43(4), penal demurrage charge. In case excessive congestion takes place in any terminal, so and so, can increase the demurrage rate even at progressively increasing rate. This is important, my lord. Subject to maximum of 6 times of the prevalent rate base. This penal demurrage rate should be implemented only after giving wide publicity. This has not been done anywhere, my lord. And due notice at terminal at 24 hours and should be applicable for notified period.
Where does
What?
it say that it cannot be given? It can be given.
No, it
Where does
can
it
be
say that
given.
it cannot be
No, no,
given?
it can be given giving a procedure. Now, Lordship, kindly see page 57, my lord. Railway board has said, my lord, that this is railway board, my lord. Why rates circular dated so and so above, the railway can increase the demurrage and even at progressively increasing rate subject to maximum 6 times of the prevalent rate. These panel higher rates
Okay,
are
right.
implemented in case.
That's right. Very issue notice.
It is-
Anyway, that is. Heard, mister?
B. Chakrabarti.
B. Chakrabarti, learned counsel for the petitioner who submits that the petitioner is a carrying contractor who
Under FCI,
transports,
under FCI lordship.
carrying contractor under the FCI who transport food grains from the railway siding to the FCI depot. Full stop. He submits that due to the late lifting of the food grains by the petitioner, the railways had imposed demurrage charges on the FCI amounting to 6 times the prevalent rate of the demurrage charges. Full stop. The FCI had in turn deducted the demurrage charges from the bills of the petitioner. Full stop. Next para. The petitioner's counsel submits that the demurrage charges at the rate of 6 times the prevalent rate cannot be done in a routine manner in terms of the letter dated 22/10/2008 issued by the Director Traffic Commercial bracket rates, Railway Board. Bracket page 57.
Lordship may record my submission that he has no direct relation and
Next,
not a-
issue notice.
agree.
Just a minute. Issue notice returnable in 4 weeks. Mr. B. Chakrabarti accepts notice on behalf
1
of
to 4.
1 to 4. While Mr. B.K. Singh accepts notice on behalf of respondents number
5 and 6.
5 and 6. Full stop. Mr. B. Chakrabarti counsel for the respondents number
1 to 4.
1 to 4 submits that the petitioner in para 18 of the writ petition has taken a stand that the petitioner has got no direct relationship with the railways. Full stop. He further submits that the petitioner's representation, that is a page, what is it?
No.
That rejection,
114. 114.
petitioner's
100.
representation dated 18/1/2024 regarding his grievance relating to the recovery of demurrage charges by the FCI by the railways which affected the petitioner's bills has been rejected by the FCI by letter dated 6/6/2024. However, the said letter dated 6/6/2024 issued by the FCI is not under challenge. List the matter after 4 weeks to enable the respondents to obtain this.
Lordship will furnish extra copies. Lordship.
Extra copies, please give.
Shielding.
Desilting.
Yes, Malata.
Okay, desilting. What is
page-
the,
Page 91, my lord.
no, just tell me, letter of acceptance dated,
Yes, my, I've given this note, my lord.
okay, this for item 11 and 12.
Yes,
Okay, sir, put it in.
11 and 12 to similar item, my lord. For both the item, I have given that.
Okay.
Package number will be different.
Huh?
Package number is
Package
different.
number will be different.
Yes, my lord, I have mentioned.
Mr. S. Bora for all the respondents. And Mr. You are Mr.
G. Alam, my lord.
G. Alam for the petitioner.
Additional.
Problem.
One of the same, my lord. The shielding matter, my lord.
Item,
12.
I know, same.
Yes.
11 and 12. Same.
Same.
Item 30.
My lord, is concerned with a very limited issue, my lord. I am running a wine bar. The license is there, my lord, but then for lifting of the stock from the bonded warehouse, Form 27 transport permit has to be issued.
From
Form
20.
27 permit has to be issued. My lord, from November 23rd, no further permit has been issued to
Why?
me, my lord. I don't know, my lord, the reason has not.
Have
been
you
said.
submitted a representation?
No, my lord, I have submitted the form. I have to submit the form for,
You submitted a form
the form is there.
and you should have submitted a representation. Why it has not been done? Why is it not being done?
Lordship, we need to obtain instructions for having this.
When? It's a small issue.
My lord,
Yes, your lordship.
have it next week, my lord. Let us have the instruction, my lord.
Next. week.
Tuesday,
Yes, your lordship.
by Tuesday, huh?
By Tuesday.
Mr. B. Pathak, learned counsel for the petitioner submits that the petitioner is running a wine bar and he accordingly needs to transport the liquor under Form 27 from the bonded warehouse
Hello.
to the wine bar. He submits that from May 2024,
November 21.
huh?
November 20.
From November 2020, from November 25,
24.
24.
from November 2024. The petitioner's transport permit under Form 27 has not been approved by the excise department without giving any reasons for the same. Ms. DJ shall obtain instruction as to why the petitioner's Form 27 is not being approved. List the matter on Tuesday.
License.
My lord, a vote has been, to petitioner.
Huh?
A work, my lord, order has been issued in favor of petitioner. The work was, my lord, actually, there was a delay, railway extended, my lord, especially saying that, my lord, there is a delay on the part of the railway. If you also see page 53 and 54, these two orders are there.
Anyway, there's a termination. Your
And
contract has
also,
been
my lord,
terminated.
what happened, my lord, no measurement has been taken and the work is lying as it is. We file a repairs on, my lord. I, direct, my lord, pray that, my lord, the railway may consider that repairs on the, only, my lord, that.
It is already terminated, Lordship.
Huh?
It is already terminated on 26.
26, oh, June.
But the work is lying as it is, no tender has been issued. So we have filed a request on, my lord. That is
Is there any arbitration clause?
the arbitration clause is there, my
Then?
lord. But the only thing, my lord, because no measurement has been taken, my machineries are lying there, no tender has been issued. So the work, my lord, I can complete it, my lord, in public interest also, my lord.
No,
So-
no, that is not the issue. The issue, let us see the termination letter,
Yes, my lord.
page
Page 60.
60.
60.
Balance work will be carried out independently without a part.
My lord.
Then?
That is there, my lord, but since then, my lord, the work is lying. And recently, that is why when we approach, my lord, them for the action, my lord, then only we come to know that the work is lying and there's no tender has been issued. We have submitted a request, my lord. We are ready to do the work, my lord.
Where is the representation?
Well, that is a request I am annexed, but that copy, my lord, normal copy has been given, the recent copy is not there.
Where is it here in your?
Page 74, my lord. But that I am giving my copy, receipt copy, my lord. Only, my lord, your losses may, if they do it, otherwise we have to go for it. In public interest also, all can do it, my lord. Even if they issue a tender, my lord, they will not start their purpose. We are well acquainted with the same, my lord. Messages are also there.
So you want your representation to be decided?
My lord, only, 2 days.
I think, my lord, yes.
That's why I will take instruction, Lordship, next week, it may be picked.
Yeah.
That's Lordship, whether it is, I have no instruction whether the balance work has been.
Huh?
The balance work has been started.
No, no, not
by
on
some
that,
other-
not on that. You just take a decision on the representation.
And earlier before termination, Lordship, they were given repeatedly given notice, Lordship, to commence the work and to make progress of the work. It does not comply with Lordship.
Look, you see, you can take a decision. If you all do not, then they can go to arbitration or wherever.
Yes, ma'am. Yes.
What is that? Just take a call.
Yes,
Just take a call on the press.
yes, arbitration clause is there, 63, Lordship.
So
Only, my lord, your lordship, my direct matter to, but whether it is decided in my favor or not, well, that is up to the my lord, not. Because the work is lying, my lord, no, entire piece, no measurement has been taken till now, my lord. And virtually twice, my lord, extension was granted due to fault of the railway. They have written it in the letter. That due to delay of the railways.
63 is there.
Yes.
If they're not agreeable, then they can always go for arbitration. We'll reflect that.
Yes. Yes.
All right. Third, Mr. G.S. Sayawara, learned senior counsel. Assisted by Mr.
M. Sahib.
M. Sayawara, who submits that in persons to NIT. What is
Yes.
it? Persons to NIT
Dated 12/1/22.
dated 12/1/22. In your synopsis, you have said contract.
Yes. For contract.
You have said contract in your synopsis. In persons to NIT dated 12/1/22. For execution of the work, namely, para 3 is there in bold. The petitioner participated in the same. The petitioner's bid being found responsive, the petitioner was awarded the work in question. While letter dated 12/1/22. For the contract value of rupees 6,08,42,172.19. Suffice to say that due to the petitioner not being able to complete the work in time, the contract was terminated by the respondents while letter dated 20/06/2020. The letter dated 20/06/2024 also stated that the balance work under the contract would be carried out independently without the petitioner's participation. Now, come on, besides the petitioner being debarred from participation in the tender
Yeah.
for executing the balance work.
That's it.
So that is already there.
But
The
that,
security deposit and the performance guarantee was also to be forfeited. Next one. The petitioner's counsel submits that
till date, no measurement has been done.
when the petitioner visited the Office of the General Manager bracket Railways for invoking clause 63 for resolution of the dispute. They came to learn that the aforesaid contract was lying half done as no retender had been done for completion of the balance work. Accordingly, the petitioner has made a representation dated
5/12. 4/12, received on 5/12.
five 2024 to the Senior Divisional Engineer / Coordination, Northeast Frontier Railway. Praying that the letter dated 20/06/2024 terminating the contract work in question may be revoked. Next paragraph. The petitioner's counsel submits that the petitioner's representation dated 5/12/2024 bracket annexure 13,
Yes, ma'am.
very close, has not been decided by the respondent authority still. He accordingly submits that the writ petition can be disposed of if a direction is issued to the respondent number 4
Yes.
to take a decision on the petitioner's representation. Ms.
Devi.
R. Devi, CGC, appears for the railway and submits that. What? And submits that there is an arbitration clause which can be availed of by the petitioner. Stop. However, but then this is only for representation.
Yes, sir.
However, as the prayer of the petitioner is only for a decision to be given on the petitioner's representation. The same may be decided by the concerned respondent number 4. In view of the consent of the parties, this writ petition disposed of with a direction to the respondent number 4 to take a decision on the petitioner's representation dated so and so. Right. Within a period of 1 month.
4 weeks.
1 month from the date of receipt of copy of the writ petition is accordingly disposed. Just so you can give back, I don't need. No, that did not be in the file. You can throw it away.
Time being motion matters. Item 4.
Lordship,
Yes.
this case affidavit has been sent for vetting, Lordship,
Okay.
to the ministry. So it is, sometime is required, Lordship. Next Thursday, Lordship. Next Thursday,
Next Thursday.
Lordship.
Okay, right. So we issue notice then because there's no one else, I think.
Notice, Lordship, since already financial bid has been opened, Lordship, notice some delay will cause, Lordship, if notice is issued.
No, you're appearing for all anyway.
Lordship,
You're appearing for all the
yes,
respondents.
Lordship.
So how will notice be a problem?
Lordship,
Because you're filing affidavit, that's why.
Lordship.
Right. Heard Mrs. S. Batra Gohain, then counsel for the petition. Issue notice returnable in 4 days. Miss R. Devi, learned CGC learned CGC appeals for all the respondents and submits that the affidavit has been sent for vetting and will be submitted within
Within, by Wednesday,
within 4 days. List the matter. When do you want?
Thursday, Lordship.
Thursday. Huh? Status quo shall be maintained till the next day.
This is relating to some electricity bills, my lord.
Huh?
Electricity bills. Actually, my lord, I'm appearing as petitioner, my lord.
Why? How are you appearing as petitioner?
I'm the director, my lord. I'm the director of the company. You also can you see page 44, my lord?
Represented by its manager, Sri Tupidar Gogoi.
Yes, my lord, yes, manager. So, my lord, the page 44, your lordship, may can you see?
No, just tell me, you see, out here, you're one of the directors
Yes, my lord.
of this Eden Cold Storage.
Yes. Problem, my lord. I've got three companies.
Huh?
I've got three companies of different activity.
Otherwise, as per the law laid down by the Supreme Court in Kingston, only a person duly authorized by the board of directors by a board resolution can represent an institute proceeding
That's right.
in case of a company.
Out here, madam, out here,
Required.
Sri Tupidar Gogoi is the one who is
Manager.
who has been authorized to represent the
Yes.
company.
Yes.
So not you. You can wear your gown. Okay. You can do as a lawyer.
If there is any, huh? No.
But you are not your name is not here.
Otherwise, there is no resolution authorizing
Normally.
Tupidar Gogoi.
There's no resolution.
At least no resolution has been enclosed here. But in Kingston, it is said that the
Because we
institute
are
proceeding.
fighting many cases for the clients, my lord.
No, madam, it's not that. It's not.
So, my lord, no board has been now for last 20 years has asked for.
Well, this is the first time is there for every time. First time is there. When the law requires. You see, I'm not on the merits. I am right now on the procedure.
Okay, still on the resolution.
If we give the resolution, it's proper. That's the proper way. Otherwise, actually, this is a notice. This case has notice has to be issued. Only then, please give the resolution. In the meantime.
By that time, next day, I'll place the, otherwise delaying. So you can also appear, madam.
Where is the Wakalat Nama?
I'll assist them.
Madam, you're not there. Oh.
Yeah.
It's not the way to do it. Not the way to do cases. Yes, your name is? Pivatnam. There are certain procedures to be followed, madam. Heard Miss P. Goswami, learned counsel for the petitioner. who is aggrieved with the impugned bill assessment and order dated 15/10/2024 on the ground that the same is not in compliance with the circular dated 5/11/2024, but 5/11/2014, where warehouse, go down and cold storage services have been placed under the industrial category of services under the MSMED Act, 2006. The further case of the petitioner is that the assessment order does not conform to the provisions of section 126 of the Electricity Act, 2003, or the Electricity Supply Code 2004, as well as the circular dated 13/11/2014. Issue notice returnable in 4 weeks. Mr. KP Pathak,
On behalf of all these,
accept notice on behalf of all the respondents. Ms. P. Goswami shall submit the letter authorizing the board resolution authorizing who?
Mr. Tupidar
Mr.
Gogoi.
P. Shri Tupidar Gogoi to represent the company and file the present case on behalf of the company.
This order is my lord, page my lord. Page 17, my lord, order. Only my lord, the lordship.
Page item?
Item 15.
I want to file an objection, madam. Today, first day it has come.
And only my lord, I want to show only this is the
No, what are you challenging here?
yes. Only
I cancel this.
Yes, what do you want to show?
my lord, this my page 36 the break petition, my lord. This we call them for discussing my lord, whether we'll cancel
Page
on
36?
36 of read petition. Read petition.
Read petition. Okay, give me. Yes. Just a minute.
We called them on 18th of May 2023 for this whether we'll cancel or not, man. Because it is 1 year, my lord, the contract was there, my lord.
Page item 36. Page 36.
Page 30. This is what impugn.
Impugn order is 36.
Yes, my lord. This is letter, my lord. Page 36, man. To be attend MES official to
Yes,
discuss.
you have challenged this.
Yes, my lord.
Concept, can you see page 34?
34.
Sorry, not 35.
Yes.
Some time and some modification is needed. to complete the work. They directly call a meeting for cancellation. Specification of the item.
No, you see, Mr. Counsel, when they are going to, whether they have to take a decision, either this way or that way. We cannot stop the decision. Let a decision be taken. They might not cancel it, they might cancel it. If they cancel it, you can always come again.
Yes, yes.
There's an arbitration clause also there.
There's an arbitration clause also. Then where is the question? How can you stop someone from taking a decision?
And only for discussion, whether we mention on whether.
Just go.
That
Actually, your notice is also not correct.
Yes, ma'am, that is.
You are saying that the proposed cancellation. So naturally,
Yes, ma'am.
he's saying that even if I go, it's going to be cancelled
Yes,
anyway.
ma'am, because ma'am, there's only 1 year completed, the contract was done 353, 65 days, there's only completed, and they, as per ISI,
No, Mr. Counsel, not that. You see, when you say, supposing I tell you, Mr. S.K. Medi, please come tomorrow. Supposing I'm the one who appointed you, say,
Yes,
as CGC. Mr. S.K. Medi, please come tomorrow for discussion
Yes.
on the proposed decision to be made regarding your disengagement as CGC.
Yes, ma'am.
Then what will you think?
Understand, ma'am.
You will think that straight away, oh, they've already decided to
Yes.
disengage me. So you should.
Court order is, page 19 of the IA, last having regards to the above projection, it is observed that though the proposed discussion.
Page 19 of
19
IA.
IA,
Huh?
Having regards to the above projection, it is observed that though the proposed discussion meeting is scheduled on 18/5/2020 to discuss about the proposed cancellation of contract agreement, but no final decision shall be taken on the matter
No,
of
no,
cancellation.
it has to be taken. There has to be.
My lord, they have not present, my lord, because there's protection from this honorable court, only discussion, my lord, but they have not done, my lord.
You turn up.
Yes.
No, let the decision be taken either way.
Cancellation fee.
So, my lord, even then, my lord, if there is, my lord, even.
You see, whether they want to, you cannot stop someone
Yes,
from
yes,
taking
I
a
agree.
decision.
I agree,
The decision has to be taken either this way or that way. You cannot stop.
but cancellation what is there?
That is the,
Yeah,
but
correct.
there is a protection. from
Correct.
this
No,
honorable
no.
court.
So it gives an impression. Yes. You also, but then of course, sometimes it's needed. Like say, in a departmental proceeding, when you issue a show cause
Yes, yes.
on the proposed major penalty,
Why should not be given?
yes, why should not be given to you? So similar. So it doesn't mean that in all cases it is given.
And only.
Only thing is that
This order.
for a contractor who is not very aware of the CCA rules and all. So when you give a word like cancellation, straight away he knows that it is that
I
going to be
understand, but
cancelled.
this order was passed, my lord, 18/5/2023.
Yes, long time.
But till that, my lord, they have not done, my lord.
You're not gone. You're not gone.
No,
You
no,
go.
no, no,
We'll
no,
fix a
but-
date. And you see when he's still working.
My lord,
On the-
my lord, that's, my lord, ISI mark, my lord, this is not.
Yes.
That ISI, that Tata,
Yes.
Tata ISI
Yes,
mark
that-
is not there.
So. that-
Anyway, why don't you give quality products, Mr. Counsel?
No, my lord.
Bhasa Dev said.
No, my lord.
Fake Bhasa, but they.
My lord,
You see, it's like buying Adidas shoes from
Yes.
near some, I won't say which state, so they'll say Adidas shoes from near outskirts of one city.
Yes.
Adidas shoes which will cost you maybe 6,000 in the thing. Out there outside, if it's made from that outskirts of that city, you'll get it for 200 rupees.
Yeah, first copy, second copy, and
First
third
copy, second.
copy. It is there.
Yes.
So please give good quality product. You are giving Tata, but that ISO mark is not there.
Yes. So, my lord, Lordship may decide, fix a date, my lord, they will, appear before the concerned authority, my lord. And my lord, if my lord.
Any given.
Huh?
My lord, as per my lord, the last this award, this letter, my lord, there is.
No, no, we are setting, you go and let them decide.
Yes,
We
sir.
cannot stop
Yes,
them from taking
yes,
a
yes.
decision. That is not correct.
Yes.
Right. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. S. K. Medi, learned central government counsel for all the respondents. Then you take this page, order dated 18/5/23, para 2. Huh. The next para 3, Mr. S. K. Medi, learned CGC submits that the petitioner has not attended any meeting with the respondents after the letter dated 3/5/23. He further submits that there cannot be a ban from, he further submits that the respondents cannot be debarred from taking a decision with regard to the contract work being undertaken by the petitioner. He submits that a decision can be made by the respondents to allow the petitioner to continue with the contract work or to terminate the petition. In the event the petitioner's contract work is terminated, he always has the remedy of invoking the arbitration clause provided in the contract agreement. Correct?
Yes, ma'am.
There's a contract agreement.
Yes, ma'am.
Where is that?
Well, the additional affidavit filed by my friend, my lord, this, my lord.
What has he said?
Running page, my lord, page 37, my lord, the additional affidavit, my
What
lord.
has he said?
Yeah. My lord, they has already,
Huh?
earlier approval, so, my lord, in their written also there, my lord.
Where is it? Okay, next. I have heard the learned counsels for the parties. The petitioner is agreed by the letter dated. Where is that page? Adi?
Which one, my lord?
That letter asking him to come for a meeting?
Yes, my lord, 36, please, read, please, my lord.
Perfect. Agreed by the letter dated 3/5/23 issued by the respondents asking the petitioner to come for a meeting to be held on 18/5/2023 to discuss the proposed cancellation of the contract. The said letter states as follows, page 36 from here to here. That's correct. Next para. Though the letter appears to convey the idea that the petitioner's contract would be cancelled on the meeting to be held on 18/5/2023. Come on. The same is only speculative in nature. It is only a proposal which need not be accepted by the respondents. In any event, there cannot be in any event, the respondents cannot be prohibited from taking a decision as to whether the contract being undertaken by the petitioner should be terminated or not. Any decision taken by the state respondent can be subjected to judicial review, provided that the same has been made arbitrarily, unreasonably, and in violation of Article 14 of the Constitution. Or the contract agreement. In view of the above, this court is of the view that the petitioner, who has apparently not had a meeting with the state respondents in terms of the letter dated 3/5/23 till today, should discuss the proposals made by the state respondents. For the said purpose, this court is of the view that which date?
Any date, my lord, second,
Is of the view that
beginning of January.
the
Any date, first,
Is
first
the-
week of January.
is of the view that yes, which date you want?
Second week of January.
Is of the view that a meeting between the
Sixth of
state respondents and the petitioner should be held on 6 January to discuss the work of the petitioner, the contract work of the petitioner, the contract work being undertaken by the petitioner. It is also made clear that in the event the state respondents, it is also made clear that no bar is being put on the state respondents to take a decision on the contract work being undertaken by the petitioner after the meeting to be held on 6/1/2025. However, in the event of any decision being taken by the state respondents to terminate the petitioner's contract work, notice in writing should be issued to the petitioner after the meeting held on 6/1/2025. The petitioner shall accordingly attend the office of the respondent number.
Respondent, my lord, four, my lord.
Attend the office of the respondent number 4. That is in Shillong.
My lord.
Shillong.
Yes.
Respondent number 4 at 10:30 a.m. 10:30 a.m. or 10 a.m.
10:30.
10:30 a.m. The writ petition is accordingly disposed of.
And earlier interim order, my lord.
The interim order passed earlier stands vacated.
Earlier.
Well, this is a kind of case. Item?
May please, Your Lordship.
Okay, right. Heard Miss
F in,
M.
F in Cas Lordship.
F. Fental. Oh. How do you spell Fental? F-E-N-T-A-R.
Lordship F I N T A J.
Intaj. Oh, F. Intaj is written. F. Intaj. Learned counsel for the applicant who submits that the Union of India so and so and Brahmaputra board. Huh? This is at para 2 it is here. Para 2 of the application. It should be treated as respondents number 6 and 7. Ms. D. Jain appearing for the Water Resource Department and Mr. G. Bokalial appearing for the government of Assam submit that they have got no objection to the application being allowed. Stop accordingly, 1 and 2 are implemented as respondents number 6 and 7. Applicant to submit a corrected copy of the cost title to the registry within 4 days. Within 4 days. I is accordingly allowed and disposed of. Then in the main case, you write, in view of the order dated 13, today's 13,
13/11.
13, 12, 2020,
13/11.
how can it be 11? This December now, madam.
Sorry.
13th of 2024, passed in IAC 3767 of 2024. So and so are implemented as respondents number 6 and 7. Issue notice to the newly implemented respondents number 6 and 7. Petitioner to take steps for service of notice upon the respondents number 6 and 7 by a registered post with AD within 4 days. This is the matter after 4 weeks.
Oh, bless you. Item 17.
Oh, sorry. No need, madam, wait. Sorry. No. Steps need not be taken. Who can accept notice?
On behalf of Ms.
6 and 7. Miss Agan. Don't take steps. Miss Agan accepts notice. CDC accepts notice on behalf of respondents number 6 and 7. Okay. And list the matter after 4 weeks to enable the respondents to file their affidavits. So steps are not necessary.
Obliger.
Correct. Heard Dr. A. Todi, learned counsel for the applicant who submits that the Commissioner Secretary, Finance and Taxation Department, Government of Assam should be implemented as respondent number 6. Mr. S. Datta appearing for the PNRD and Mr. G. Bokalel appearing for the state government submit that they have got no objection to the application being allowed. Accordingly, the Commissioner Secretary, Finance and Taxation Department, Government of Assam is implemented as respondent number 6. Applicant to furnish a corrected copy of the cost title to the registry within 4 days. The I is accordingly allowed and disposed of. Then you write in the main case. In view of the order dated 13/12/2024, passed in IAC 3846 of 2024, the Commissioner Secretary, Finance and Taxation Department is implemented as respondent number 6. Issue notice to the respondent number 6. Who will appear for number 6? Mr. Just a minute. Mr. H. Barwa appearing on behalf of Mr. B. Gogoi accepts notice on behalf of respondent number 6. Mr. H. Dubai, R. Dubai appears for respondent number 3. Full stop. Mr. S. Data appears for the PNRD department, while Mr. G. Bokalian accepts notice on behalf, appears for the state government. List the matter after 4 weeks to enable the respondents to file their affidavit.
Item 18.
Same order. Same I number 3847.
Out here, I 3847. Same order, huh?
What's up?
For item 51.
Yes,
Make results.
let us see the documents.
Now, the two pages, if your lordship sees page 157 of the record first. But here, my lord, as regard the pending bills, and inquiry committee was formed, my lord. And now your lordship sees 177.
Yeah,
Well, there is a bill of 2,92,390 if your lordship sees
2 lakh,
92,390.
yes,
But your lordship sees this is the claim amount, and on the right hand column, Lord, they have inquired and finally to be 270.
2 7.
Lord, so far as the claim of the petitioner concerned, Lord, election department and PRRD admit only this amount. Lord. And Lord, just I want to point out one aspect of the matter. If your lordship sees the bill submitted by the petitioner in the writ petition, and before that, my lord, in page 13, my lord, the petitioner was only issued work order for videography, my lord.
Okay, just a minute. Page 13.
Yes, my lord. The work order was only in respect of videography.
So 27,000.
No, my lord will now come to page 15 for a moment.
You said page 13.
27,000 is the rate.
Okay, yes, per
This is
day.
this is the work order. And now, my lord, this,
27,000 for 14 days.
yes, my lord. Now 8,000 daily. At the top, your lordship would see.
Okay,
And for course order cassette 60 numbers, it has been fixed at 27,000.
okay.
Now your lordship sees at page 15, my lord,
50.
15, the repetition itself.
Yes,
My lord, they have submitted before your lordships an undated bill. Your lordship sees there is no date as such.
Ah.
And there in page 15, it is written as bill number 1. At the left hand corner, my lord, before the
yes, yes.
next page, your lordship would see bill number 2.
Ah,
And the third one, your lordship would see bill number 3.
yes.
And total amount to 20,08,692. Well, this bill has never been issued upon us. And lordship would kindly take note, Lord, that at page
So it's not,
22.
not submitted to the election commission.
No. And page 22, sometime in 2019,
Yes,
But they submit it to the PNRD department, my lord,
okay,
and they forward it to us.
okay.
Now your lordship would kindly come to our affidavit we have
But
filed.
page 22 is for how much? Is for an amount of rupees 20 lakh.
Yes, and it has been addressed to Commissioner PNRD. And that too is 2019, my lord.
And out here, just how much is this?
And an extra 5 lordship. Yeah,
Just a minute, madam, you'll get your turn. Out of 20 lakh, okay, yes.
If your lordship take our affidavit, my lord,
As point number 2.
yes. At page 26, my lord,
Yes,
your lordship sees this is the bill for 2,92,390. Page 26, 27 together. And in page 26, in the body, my lord,
26 is a affidavit. Para 5,
no, my lord, in
lordship of the.
the annexure, my lord.
annexure,
So perhaps, my
annexure.
lord, the sequence of the, my lord, earlier it was filed. Running page may not be same, my lord. We'll see the internal page of that affidavit.
Please
Yes, my lord.
make the running page. I do not know
No,
that
no,
I have
my lord.
26, just a minute.
20
26. Ah, okay, I've got this 26. This one,
Has your lordship got, my lord?
this one.
Yes.
Yes, yes, yes.
Yes.
My lord, in the repetition, your lordship has seen bill number 1.
Ah,
Here, there is nothing bill number 1 as such.
oh,
And on
yes.
the right side, your lordship would see the endorsement
Ah,
certified that the proprietor of the firm has attended. So we have certified this amount, which your lordship sees as paid 27.
so this is for 2 lakh
90.
92. Ah,
That has been certified, and in inquiry, it was found to be 270
lakh.
from the record your lordship would see. And then next, your lordship would also see page 29
Yes.
is a type copy of 2030. My lord will see there are 5 categories, my lord.
Ah.
Videography, observer, and intercom facility, advertisement, hire. But these are for other smaller vendors, not for my lord, the petitioner, because he has only been given work order for videography.
Ah.
And this part of the same details was furnished to the inquiry, which your lordship has seen in the inquiry. So, my lord, this has already, all of a sudden has come up, my lord, in 2019, my lord.
So,
And PNAD is the authority, my lord, who will make the payment, my lord.
Not to verify.
ah,
Not to verify, man.
not to verify?
Well, not PNRD only the authority for payment. But
Ah.
for verification.
So they are verifying, they are verifying. So madam, why have you made claims for which you have got no reason to make a claim?
No lordship.
Getting greedy.
Lordship, as they have said, the work order is annexure 1 of the writ petition, lordship.
Work order is for only for videography, correct?
Videography, telecasting.
Huh? All dollar signs are showing now. Is it?
Then, no lordship, annexure 2 is there where the work has been extended, lordship.
Work of what, madam? What was the original work order?
Videography, photography, and telecasting.
Huh?
Videography, photography, and telecasting. The, there is camcorder, cameraman, sound recording, helping, editing.
Let me see your work order. Let me see your work order.
Work order is annexure 1, lordship. Of,
What does it say?
writ petition, page 12.
Page
Type
12.
copy is page 12 and page 13, lordship, not clear.
Actually, work order is, my lord, page 10.
Page 12 of the writ petition.
Because what we have
And
issued to
the-
them.
Page 10?
Yes, in the writ petition, annex, oh, sorry, my lord.
Repetition
In my
is
writ-
PL clause. Check their case 13.
The same order is there in my affidavit, sorry.
Yes,
my lord.
same order.
No, out here, but we do not know what exactly they're supposed to do, the petitioner. What exactly are they supposed to do?
My lord, if I can read the work order. my lord.
Yes, yes.
The commission examined the rate at which work orders are issued to firm by the senior student post. After considering various aspects of the issue, commission is pleased to fix daily rate of 8,000 rupees against work item 1, 2, 3 of the camcorder,
1, 2, 3, and 4.
camcorder, cameraman, sound recording, and editing. So basically, this relate to in his latest office.
Okay, it is submitted by Aryan Media.
Yes, yes. So basically for videographing only.
Only for this, 8,000 per day.
And blood a fixed rate of 20,000 was to be payable for car recorder, cassette 60 numbers, my lord. And if the period is extended, my lord, the same work is to be extended. It's not that something new work order has been issued to them,
Anyway, you have admitted only that small amount.
my lord.
Well, what?
Actually, here in this case, the petitioner had already expired, Lordship. So. He has been.
So the substituted,
Yes.
the heirs will get
By
it.
his wife.
Wife.
So now we don't.
Wife and children.
Children, one child is there.
One child, okay.
So, wife.
Okay, so let the wife get it.
Now, actually, we would not like to dispute the
Huh?
amount, Lordship. We would not like to dispute the amount. Whatever she gets, she is happy with.
Okay, right. Heard, miss?
Yes, yeah.
But can I make one submission, lord? But that is the amount determination 270. Lord, whether it has not paid or not, lord, that is not clear. Your lordship would say, if it's not paid, we will pay. The
This
PNRD
will
will
pay.
Heard, Miss S.C. Ahmed, Learned Counsel for the petitioner. Also heard Mr. R. Dubey, Learned Counsel for the
State Election Commission.
State Election Commission. So, sir, Mr. S. Datta appears for the PNRD department. The petitioner's case is that the petitioner had been given a work order by the Assam State Election Commission on 6/12/2007. And after completing the work, the petitioner was to be paid the outstanding bill amount of 20,08,69. However, the same has not been paid to the petitioner. Next para. The petitioner's counsel submits that the petitioner died during the pendency of the writ petition. And he has now been substituted by his wife. What is his wife's name?
Purnima Bansal.
Purnima Bansal. And so just give me that. What is this?
She is there.
Huh?
1082.
Yes, just give me that. Cannot reach. Purnima Bansal, huh? Next part. Mr. R. Dubey has produced the official records. And as per the official records, it is seen that the petitioner had submitted a bill amount of rupees 2,92,390 only, and not the amount claimed in the writ petition. The official records also show that the Commissioner, Panchayat and Rural Development Department, Assam. No, it also show that an inquiry had been instituted to go into the claims of the petitioner and other persons. First up, the inquiry committee came to a finding that out of the rupees 2,92,390 claimed by the petitioner, the amount payable to the petitioner was 2,07,700. This is reflected in the letter number PDDP bracket Roman 3 bracket close 42/2007/PT full stop Roman 3/499 dated 28/1/2013 issued by the commission issued by Dr. K.K. Dwivedi, IAS, Commissioner, Panchayat and Rural Development, Assam, to the Principal Secretary of the Government of Assam, Panchayat and Rural Development Department, this. Okay, should I say the letter number once more? I'll just say PDDP capital, bracket Roman 3, bracket close 42/2007 /PT full stop Roman 3/499 dated 28/1/2013. Okay. Full stop. Next paragraph. The above being said, the problem pagination is not proper, no?
The internal page 26.
Now, which 26, I do not know. Then again is a problem. The above being said, the claim of the petitioner in his in the writ petition shows that there were 3 bills made amounting to rupees 20,08,69. However, in the bills that were in the petitioner's bills that were annexed to the affidavit in a position filed by the respondent number 2, it is seen that the format of the bills, format of the petitioner's bills was different than that in the writ petition. Further, the bill of the petitioner in the affidavit of the respondent number 2 was only for an amount of rupees 2,92,390. Next paragraph. The above being said, the fact remains that this is a writ court, and when there are disputed questions of fact requiring evidence to be recorded, the proper forum to avail by the petitioner would be the civil court, where evidence can be recorded. In the present case, the official records of the respondents show that the petitioner had made a claim for only 2,92,390, out of which 207,700 was the admitted amount. In that view of the matter, this court is of the view that the petitioner would have to be paid the admitted amount of rupees 2,07,700, if not paid earlier, if not already paid. Accordingly, the PNRD department
They have to file application before election committee. They will forward.
This is this letter
Part
is
of
here.
record is there.
It is your letter.
Penat.
KK Dwivedi to say.
What did दिखाई दे?
It is here. You take this photo. Okay. And you give me this photocopy of this letter. Accordingly, Mr. R. Dubey, learned standing counsel for the Assam State Election Commissioner, shall give a copy of the letter dated 28/1/23, issued by the Commissioner, Panchayat and Rural Development, Assam, to Mr. S. Datta, learned standing counsel for the PNRD Department, who shall forward the same to the concerned authorities. Full stop. The PNRD Department shall thereafter make payment of the admitted amount of rupees 2,07,700 to the petitioner. To the petitioner, what's your name? That
Purnima Bansal.
Purnima Bansal, within a period of two months. 3 months. Within a period of 3 months from the date of, from today, comma, if the said amount has not been paid earlier.
May I pay for a copy of this order?
It'll be uploaded. Yeah, we'll take it. The writ petition is accordingly disposed of.
Hello.
Just a little water, huh? No, what?
I can give
Item?
you.
Admitted? No.
Impose cost in this case. He has received the whole amount in 2020 itself lawsuit. After that, 21 he has filed his restriction lawsuit. Otherwise, lawsuit, that thing should be going on lawsuit. Courts, judicial time lawsuit as well as lawsuit. Everybody's time is consumed. Registry has to do other important works also, honorable courts registry also. They are misleading the court, so lawsuit may impose cost in this case. They have consumed the precious time of the judicial lawsuit.
No, we did postcards. No.
Lawsuit may impose cost. Otherwise, these things, they will come again and again.
Or you file an affidavit, then we'll postcard.
Lawsuit may indicate lawsuit. First part lawsuit may indicate I will file affidavit.
Yes. No, you file it by Tuesday, we'll post cost on Tuesday. Heavy cost will impose. What is the amount claimed?
They have claimed lawsuit almost 10 lakhs lawsuit. 10 lakhs 63,660 lawsuit.
Or better, let him, while he's there, we'll dispose it off better, maybe.
Lawsuit.
Just add this amount up. Just add this amount up in your phone.
Lawsuit kind.
Just give it to me. Yes, Mr. Mohan. What is this? What are you doing?
Ten lakhs 63,665.
Oh, exact amount is claimed.
Exact.
Just show it to him, let him just. You take a photo of it if you want.
I will file a affidavit, then he
You
will.
can file affidavit, I will reply.
Otherwise, lordship,
No, no, you no need of reply.
Yeah.
Yeah, I mean, you obtain instructions. Okay, right. Mr. L. Mohan, learned counsel for the petitioner, and Mr. K. Gogoi, learned counsel for
all are responding.
all the respondents are present. Next, Mr. K. Gogoi has submitted a letter issued by the
Issued by the lordship Deputy Commissioner of Police Administration, Guam.
Deputy Commissioner Police Administration, Guwahati, which is to the effect that the amount of rupees 10,63,665 claimed by the petitioner as vehicle hire charges has already been released to the petitioner in the year 2019. He accordingly submits that costs should be imposed upon the petitioner for wasting the court's time and coming to this court with a fabricated case. First up. Next para. The letter number ECP/higher charge/High Court/2023/5118 dated 29/8/23. Issued by the Deputy Commissioner of Police (ADMN) Guwahati. States as follows. Take it from here to here. Okay. First one. Mr. K. Gogoi shall submit the said letter in the form of an affidavit. By
lordship Monday, I will file.
Okay.
Tuesday, by Tuesday.
by Tuesday. List the matter on Tuesday. Mr. L. Mohan shall in the meantime obtain instructions with regard to the order passed today.
My lord, may fix the matter on Wednesday, lordship, I will file on Tuesday.
List the matter on Wednesday. So tell him to come with a checkbook.
Lordship, I will take a photocopy of the letter, lordship.
How you get it? He also can take you.
First, I'll
It'll be in the order anyway.
No, oblige, lord.
What to do?
Well, in fact, Malad, we are also yet to receive instruction.
Okay, right. No one appears for the petition on call. Mr. B. Chakrabarti.
B. Chaudhary.
B. Chaudhary, the counsel for the APDCL, is granted 4 weeks time to file affidavit. This is the matter.
My lord, in this matter, I am going to file affidavit in reply today, my lord. Matter may come next week or first week of January, my lord.
It can be fixed for hearing now.
My lord, that's the admission, my lord.
Mr.
MCK, my lord.
MCK is granted a further 3 weeks time to file affidavit in reply.
My lord, I am going to file today, my lord.
Oh, submit that he will be filing affidavit in reply during the course of the day.
Yes.
Accordingly, release this matter for hearing.
My lord, that's the admission.
Yeah.
That's the admission, my lord.
Accordingly, release this matter on. Don't say hearing. When? After the vacation. After the BU vacation.
3rd January, my lord.
No, it's too many cases there. After the BU vacation.
Lordship, one correction,
So this amount was paid after filing of the repetitive.
On 22, it was the below mentioned is the period losses.
Oh,
It was
Below mentioned
paid
is
after
period.
the filing of the
Loss in the
repetition
close
in the year
it. Below mentioned is the period
2022.
loss. Below mentioned is the period loss.
It's not there.
can you obtain it into, you call him just now at 2 o'clock, we can dispose it off.
Okay, I will take it.
Otherwise,
Okay.
also below mentioned is the
Just say,
period.
don't put this date,
That is the
don't put this date. Otherwise, put it like this, sorry.
Loss.
Just pass it, I'll correct it.
Loss.
Just obtain instruction by 2 o'clock, we'll take it up at 2,
Loss.
if it's paid or not. At 2 o'clock, huh, madam, at 2.
May please, your lordship. My lord, in this method, 33% payment has been made, my lord. And the other remaining 67% has yet to be paid.
50% has been paid.
33%, my lord.
Huh?
33% has been paid.
No affidavit, what to do? Mr. Nayak is here. What is to be done?
My lord, method will be taken up after some time, my lord. When we have.
Okay, after some time.
My lord.
Next, after some time.
This regarding non-payment of completed bills, my lord. Wow, my lord.
Let the authorities verify.
and pay
Huh?
completed
Verify and pay your lordship.
2 months.
The instruction not coming.
Heard Mr. S. Bora, learned counsel for the petitioner, who submits that the petitioner was allotted various work orders by the respondent number 3.
One note. It is the 20, what it is done, number 2. The 4 work have been
For repairing, operation and maintenance of different pump motors, valves, pipelines, etc. By the respondent number, respondent number 3. Though the petitioner has been paid some amount of his contractual dues, the balance amount of rupees 18,33,557 has not been paid to the petitioner. Ms. R.R. Goy. No, the petitioner's counsel submits that a direction may be issued to the respondents to verify the bills of the petitioner and to pay to the petitioner the admitted amount. Full stop. Mr. R.R. Goy, the learned counsel appearing for the PhD department.
1, 2, and 3, your lordship.
For the respondents number 1, 2, and 3. Submits that he has got no objection. Acha, who is for 4? Finance.
Finance.
And Mr. P. Nayak appearing for the respondent number 4 submits that they have got no objection to the prayer made by the petitioner's counsel. Next paragraph. The work orders and the status of the work undertaken by the petitioner along with his claims are reproduced here in below as follows. Page 10, 11, and 12. It is in the form of a chart, okay? Yes, sir. Para 4 of the petitioner's writ petition states that rupees 4,13,730 has been paid. Thus leaving a balance of 18,33,557. Next para. In view of the consent of the parties, who is to decide? The chief engineer?
Chief engineer, chief engineer.
The respondent number 2. 2 is directed to cause a verification as to the cause a verification with regard to the claim made by the petitioner and pay the admitted amount. The entire process should be completed within a period of
3 months alone.
3 months
It will be 2 months.
from the date of receipt of a copy of this order. 3 months is good enough. Because March, it'll just come within March.
That's the habit.
You file it by this month.
Next is also same. Only thing is it will be
Out here, how much?
out here. It is 9 lakhs 93,426.
How much has been paid?
No, nothing has been.
Out here, nothing has been paid. Out here, no amount paid, huh? And the work orders are there.
Work order that this is work order executed by respondent number 4.
Pay para.
Work orders start, madam.
Yeah, chart is
Chart
where?
is there, madam. Page number paragraph, page number 8, 9,
Okay, you take that, huh? That's all.
8 and 9.
Okay.
Only 3 work orders.
Okay.
All right, sir.
Thank you.
This is for payment,
Payment.
contractual dues.
Yes.
What does the affidavit say? Affidavit does not say anything, I think.
Yes.
Affidavit in a position. Yes. Who is for the respondent number 1 and 2?
Lordship.
So what have you said? Do you admit to the amount? Do not admit to the amount? What?
But in the affidavit, my lord, it is not clearly mentioned.
Yes, so we will call him. He doesn't want to tell the truth to the court. Right.
Okay, give me the last chance to, my lord, that obtain the proper instruction to whether it is admitted or not.
He wants to play around with the court. We'll play around with him also.
Then, my lord, kindly give me the last one. Let me take
This is
instruction.
not the way. This is not the way to file an affidavit. Right. But please get proper instructions by the next day.
Lordship. My lord, that in the affidavit, we have stated that, my lord, that prior approval of the revenue department, my lord.
No, that is okay. Prior approval has been given or not, that's not the issue. What is the admitted amount?
Lordship, lordship.
That has to be clarified.
Lordship. The next that I will, my lord, support.
Mr.
SN Adhyapak.
Huh?
SN Adhyapak.
SN Adhyapak appeals for the petitioner. Mr. J. Handik appeals for the revenue department. While Mr. M. Barwa appeals for? M. Buyan appeals for?
Respondent numbers 3, 5, 6, and 7.
3, 5, 6, and 7. First stop. Mr. K. Gogoi appeals for? 4. Anybody else? Mr. Naik is there? No. First stop. The petitioner has paid for payment of his contractual dues amounting to how much?
81,63,000.
81,63,000. Which is payable by? Payable by whom?
Respondent number Respondent number 4.
Who has issued you the work order?
Effective Respondent 5.
Which department is that?
PWD.
Yes, fine. Why aren't you filing any affidavit? Right. The affidavit filed by the respondent number 1 and 2. Is ambiguous. And the same has not specified the amount admitted, the admitted amount payable to the petitioner. Mr. J. Handik submits that he will obtain instructions with regard to the affidavit filed by the response number 1 and 2. So Mr. M. Barwa shall file his affidavit within
3 weeks now.
within 3 weeks, specifying the admitted amount, if any, payable to the petitioner. This is the matter. After the petition.
In this matter, we are supposed to file an affidavit. Some time we seek, my lord. We have written to the department. They'll be sending us.
Mr.
A. Fukan, my lord, for the standing council GAD, ma'am.
Standing Council JD. Who else?
PWD, I am.
Miss M. Buyan for PWD are granted
After vacation, ma'am.
4 weeks time to file affidavit in the
Deeply
person. This is the matter of the phone.
Deeply appraised.
35 and 36 similar, we need some time notice.
Okay, Mr. Gogoi is granted 4 weeks time to file affidavit.
36 also similar.
36 also said.
Lost. Obliged.
Matter pertains non-payment of bill, no affidavit has been filed.
So we give them time.
Yes, respondent number 3 and 4 has to file affidavit.
3 and 4. There is Mr. Bokalial. And Mr. G. Bokalial, you are for respondent number 3. And who is for respondent number 1, 4, and 5? Earlier it was Miss S. Sharma. Huh? Two, Mr. S. Datta appeared for 2 earlier.
Lordship.
So who is going to appear for 2 today?
Lordship,
You will appear. Yes, Mr. Buyan, here for whom?
One.
1, 4, and 5, Lord.
Okay, right. Mr. G. Bokalial. For counsel for respondent number 3, Mr. M. Buyan, counsel for respondents number 1, 4, and 5. And Mr. J. Handy for respondent number 2. Are granted 4 weeks time to file affidavit. So this is the matter of the point.
Hello, I have received a message that the amount has been sent through Indian Postal Mail yesterday.
Okay.
And regarding my lord, payer number 2, delay payment and interest, I may be allowed to approve the civil court for compensation and interest.
So you have sent your postal address
Yes.
and it is, okay. Have you sent it by post?
Yes, Lord.
Okay, right.
Release, Lordship. Kindly see the last page, Lordship.
Yes,
That word release, Lord.
okay, right. Heard Mr. N. Sharma, learned counsel for the petitioner, and Mr. P. Nayak, learned counsel for the GMC. Then you take this, the last order, the second paragraph, huh? Then third paragraph is Mr. P. Nayak, learned counsel for the GMC, submits that the EMD has been returned to the petitioner through
Registered code.
registered post. Full stop. Mr. N. Sharma, learned counsel for the petitioner, submits that in view of the return of the AMD through by registered post, comma, the writ petition can be closed. Full stop. However, liberty may be given to the petitioner to approach the appropriate forum for recovery of,
For compensation,
for what?
for delayed payment. Interest. delayed
Lordship,
payment.
whatever interest has agreed upon that instrument, Lordship, he will receive that on. I am not going to get that.
Then you go, why should I will,
That observation.
no observation here. Okay, I will just write, this is your thing, I will not say anything. May, to the appropriate forum for making a claim for interest
And
on delayed payment of the EMD. On considering the fact that the prayer of the writ petitioner for return of his EMD
prayer number 2.
has been redressed. This court, this court is of the view that the present writ petition has become infructuous. Accordingly, the writ petition has become infructuous. मैं चलो एक मिनट yes yes we'll finish खत्म करेगा पहले खत्म करेगा
Yes, my lord. I'm supposed to give the original today. So today they inform me that today they will be giving me the original. So I will be place it on Monday, my lord. If your lordship can't.
At least I can give the photostat.
He can give the photostat, the original they will place me.
Because 2000 all 11, 12 registered.
Monday we have fixed too many cases I think no have we how much is there fixed I don't know
No purpose in serve, Lordship. Approximately.
We have the copy.
no purpose
Public interest.
no
Because he is out of station, the secretary, he
Huh?
told me that the secretary is out of the station of the.
Uh-huh.
So he told me that today he'll give me the original.
No, if because no, basically he's brought out a point, legal point.
No,
That legal point-
Unfortunately,
that legal point also I am addressing, Lordship. Here the requirement is not continuous 3 years, Lordship. Here the requirement is no hours of requirement not
for more than 3 years.
not
But
yes
yeah.
only 3. It is not that the
No, but then his case is that at the time when the okay. No,
Lordship,
but we have to see whether 3 years or not. We have to show that
yeah, Lordship, may kindly see that last 2 pages, Lordship.
last 2 pages.
Yeah. This is first one is of 11, 12, Lordship. It was valid.
Okay, 17. is it?
2014.
Okay.
And next one again
Uh-huh.
renewed, Lordship, up to 2017. So
Anyway, he's not. Yes, where is it?
Conducting council is on next, lordship.
We'll take it after lunch. After lunch.
Lordship, one matter is pending, Lordship. Item number, Lordship, fix this matter at 2, Lordship. Lordship, in this matter, we have received instruction and the authority rejected the claim of the petitioner. Lordship, allow me to file the affidavit. They will get the opportunity to file this time. Item number 30.
Item 30.
Yes, sir.
Wait, one thing, item 30.
Yes, sir.
Yes, okay, item 30. Mr. P. Nayak submits that the petitioner's representation has been rejected. But
What committee was constituted? Committee verified the matter and then rejected the claim of the petitioner.
correct, so now you want to file affidavit.
I want to file that.
Mr. P. Nayak submits that the claim of the petitioner has been rejected by a committee constituted by the respondent. He is accordingly granted, how much time?
Transport take after vacation.
He is accordingly granted 2 weeks time to file affidavit. To that
Kindly
effect.
Make it 3 weeks. Sir.
By 3 weeks
There
time.
is Vacation in.
Release the matter after the vacation.
Well, this may be.
It's going to be bad news for you. You're in a hurry to get that bad news.
But after due vacation, madam, please.
Okay, give a date. Just a second. Okay. Okay.
Right, and we will, order will start. Oh.
I can put the order to online file.
We have filed the application for implement of lesson number six, but I want to
Huh?
notice that we have filed an IA application for implement of parking.
You want to file IA?
We have filed
Already
an
filed.
they have already filed IA for implement, and as per the last order 13/11/2024 in the IA allotment, they were also filing affidavit. In regards, because there is another country liquor shop in the same premises. Once that they've taken objecting that one about. They were also filed affidavit in that regard.
Who is to file affidavit?
The
So you need time to file affidavit of what?
I want to withdraw this IA application.
You want to withdraw the IA or in petition?
No,
No,
I am the
IA.
petitioner.
I 175.
You want to file, you want to withdraw the, okay. Miss
Arbegum.
R.
Arbegum.
R. Begum, learned counsel for the applicant, prays that she may be allowed to withdraw the IA. The same is not objected to by Mr.
A Chaudhary.
Huh?
A Chaudhary.
A. Chowdhury, learned counsel for the writ petitioner, and Mr. R. Gowai, learned counsel for the excise department. The IA is accordingly dismissed as withdrawn.
Lordship,
The application, not IA, the application. Huh?
interim may be continued.
Then what about the main case? The main case. So you don't want to come, so now you can go. So it's happy for him.
Yes.
Happy news for him. Yes, now who is to file? You have to file.
No, I did not file your lordship. You received instruction, and since there's already a country liquor shop in the same vicinity, in the same place, your lordship. And there was no objection regarding to that. Even NOCs were taken from local people also, your lordship.
So what remains? Nothing.
Nothing remains, your lordship.
So this should be allowed. What is it?
They're not filed.
So he's got all the permission.
He's all got all the.
If there is another country liquor shop, is that a reason to close it, or is that a reason for disallowing his shop to be there? No.
No. May I please instruction, lordship?
Yes, what is the instruction? But no one has come.
No one has. In fact, the premises is even the same, your lordship.
So Miss Begum was the one who was supposed to come, but now she is withdrawn. How come? As the writ petitioner, done some social work here and there, I don't know. Yes. So, okay, right. Heard Mr. A. Chowdhury, learned counsel for the petition. Also heard Mr. R. Gowai, learned counsel for the excise department. So your shop has not been opened.
Open.
It's open now. The petitioner's case is that the petitioner is an IMFL of licensee, comma, who had applied for transfer of license premises from Tokobari 80 Road, Guwahati to Hengarabari near Nabodaya Path, Guwahati. And you take this order dated 13/3/2024. Take the first paragraph, okay? Take the second paragraph first, okay? I will change it here and there. Huh? Then the petitioner's counsel submits, third paragraph, that the petitioner has opened his shop, IMFL off shop, and has been running the business since
8/2/2020.
8/2/2024. Next para. Mr. R.R. Gogoi, Learned Counsel for the Excise Department, has submitted the instructions slash parawise comments received by him by letter dated 12/3/2024, issued by the Superintendent of Excise, Kamrup, Guwahati. The parawise comments is to the effect that as complaints were received from people residing in the neighborhood of the petitioner's IMFL shop, inquiry was conducted. Correct? Inquiry is conducted. Paragraph 4 of the instructions slash parawise comments further states that based on the application for shifting of the petitioner's IMFL off shop, the Deputy Superintendent of Excise, Kamrup Metro, was asked to submit a detailed inquiry report in relation to the shifting proposal, and in this regard, a meeting was held on 11/8/2023. In the said meeting, the people of the neighborhood were present and they expressed they had no objection regarding the shifting proposal, inasmuch as a country spirit shop bearing license number 24/2021 was functioning at the same premise. Next paragraph. Mr. R.R. Gogoi submits that as the petitioner has been given all the requisite permission to shift his IMFL off shop to his present establishment, the petitioner can continue to do his business therein. I have heard the learned counsel for the party. Though some complaints have been made against the petitioner, the parawise comments show that the people of the locality had not objected to the shifting of the petitioner's IMFL off shop in the meeting held on 11/8/2023. Even if there had been some objection to the shifting of the petitioner's IMFL off shop, the fact remains that there is already an existing country spirit shop which is operating in the same area, for which there is no objection being raised by from any quarter. As such, it would be arbitrary if only the petitioner is not allowed to open his IMFL off shop, while at the same time the country spirit shop is allowed to operate its business from the same location. considering the fact that no objection has been raised from anybody in this court, and as all the required procedures had been followed by the excise department for transferring the IMFL off shop of the petitioner, this court is of the view that the prayer of the petition to set aside the verbal instruction given by the excise department to the petitioner to not to open his IMFL off shop has become instructions.
And your notice, impugn notice dated impugn notice dated 2024.
Page?
Where at 20.
It's page 20. Gustav. Consequently, page 20.
Page 20 in prayer.
20?
Page 20.
20.
20.
How can 20 is your prayer?
Lordship, then your lordship.
This is your writ petition, this is your prayer. Where is the notice? Huh?
Page 50.
Page 50. Your lordship.
Huh? 50. Consequently. No. Now, how does it matter? What is this?
Impugn notice was issued and inviting the complaint from the law.
So they have not shown anything, Gustav. As the excise department has not been able to show that any objection has been received by them pursuant to the notice dated 20/02/2024. Wherein people residing within 75 meters from the petitioner's shop were to submit their grievances / complaints. This court is of the view that the writ petition has become infructuous. Further, the petitioner has already opened his shop with effect from February 2022. In view of the reasons stated above, in view of the fact that the petitioner has been allowed to open his IMFL off shop by following all the procedures and as allowed by the excise department, the writ petition stands closed as infructuous. Next.
As per our affidavit, paragraph 7, my lord may dispose of the matter.
Affidavit?
In paragraph 7, lordship, we have stated, lordship. Page 44, internal page, lordship. Running page, lordship, 44. 7.
Okay, so how much is the amount?
Lordship, amount is, lordship, 42,17,910, lordship.
Okay.
So lordship may indicate that paragraph and lordship may dispose of it.
Okay.
Because detail is there, lordship.
Different vehicles, huh?
Lordship, defined vehicle, almost 20 vehicles is there, lordship.
Huh?
20 vehicles, lordship, 20.
No, there are only 3 vehicles.
3 vehicles, but bill is 20 bills is there.
Huh?
Bill is 20 lots.
Different dates.
That is a different thing, but 3 vehicles. Right. Heard, Mr. Jar Burburia, learned counsel for the petitioner, and Mr. K. Roy, learned counsel for the
all the respondent.
The petitioner's case is that his vehicle hire charges amounting to rupees 42,24,036 for the use of his vehicles bearing registration numbers AS01 DC-5823, AS13 C 4246 and AS 01 FT 8526 has not, what was it? Has not been paid.
As per the record, so the admitted amount is 42 lakhs.
I know. That's why Mr. K, the Mr. K Gogoi, the learned counsel for all the respondents submits that in terms of the affidavit filed by the respondent number 6, the petitioner's vehicle hire charges that is payable by the respondents amounts to rupees 42,17,910. Next one. I have heard the learned classes for the parties. The respondent number 6, who is the Deputy Commissioner of Police (ADMN) Guwahati, in his affidavit at para 7, has given a chart showing the vehicle numbers and the dates on which the vehicles were used for hire by the respondent. The chart also shows that rupees 42,17,910 is the admitted amount of hire charges that is payable to the petitioner. The affidavit of the respondent number 6 further submits that the payment of the admitted amount would be made on the approval of the sanction and allotment of the required funds from the sanctioning authority. Next. In view of the fact that the respondents have admitted that they owe rupees 42,17,910 to the petitioner, the respondents are directed to give the necessary sanction for payment of the above said amount and provide the funds available for payment of the same to the petitioner. The entire exercise should be concluded by the respondents within a period of 4 months. 4 months from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
Another thing, my lord, item 22, my lord, my learned friend has submitted that we received the payment in the 19, and but it is the wrong submission, my lord. She says already paid.
That's a wrong submission. That no, we'll correct. That will
Anyway,
correct.
my lord, we
But-
received the payment on 31/8/22, my lord.
Okay, give me item 22. That
What-
one.
Only, my lord, doubt is that, my lord, there is a 2 district income group, my lord. So we have to examine, my lord, lordship fix the matter on Wednesday or some other.
For what?
Because, my lord, we have received 9,81,000. There is a 2 district in Kamrup, my. Kamrup Metro and Kamrup Rural. Detail is there also. Detail is there. Against the vehicle, detail is there.
There is no, you see, no, you see the details of, details are,
The second page, lord. Details. No, I can actually. That is what.
no, there's nothing to decide here. What is there? There's not 9 lakhs. You have been paid 10,63,000.
10 lakhs, lord. But he received the payment, my lord. I've taken instruction over phone on 31/8/22, 9,81,000. Which either Kamrup, Metro or Rural. That's why I need, my lord, 1 day time. Otherwise, no say not.
You go to civil court if you're not happy with it.
Received the money on 2022,
Correct,
even
correct.
2023 also matter was listed. Then
With
also they
regard
have
to, your fees, you talk to him separately. We're not going to go into those.
Even was it 23 matter was listed. then
Correct,
also they
correct.
have not- They have not lost it.
This is the instruction that has been given, so end of the matter.
That may be.
Okay, right. Mr. Out here, I'll just wait. It's already written, huh? More In the year 2022, I think. huh?
Lordship, 2022, Lordship.
Okay, next, right, just a minute, I don't know, para 1, 2, 3, 4. Item, para 4, right? The, acha, para 2, you write. Mr. J.I. Barboya, learned counsel for the petitioner submits that the petitioner's vehicle hire charges of rupees 10,63,665 has not been paid. Huh? Then you say, or should I not say this? Cut this. No, I won't say this. I won't say this. Don't say anything. 1, 2, 3, 4, 4. Then you write. At 4, you write. Mr. J.I. Barboya submits that he has obtained instructions and
Date maybe.
he has been informed that the petitioner has been given his higher charges, bill has been given the higher charges, no, has been given the vehicle hire charges in the year 2022. However, he is not sure with regard to the exact amount received by the petitioner. Next paragraph. On considering the fact that a calculation of the amount given to the petitioner by letter dated 29/8/2023 is rupees 10,63,665, which is the exact amount obtained by the petitioner. This court does not find any reason to keep this writ petition pending any longer. Accordingly, the writ petition is closed due to the petitioner's vehicle hire charges being given to him. Full stop. In the event the petitioner is of the view that the petitioner should have received, the petitioner has not been given the amount claimed by him, he may approach the appropriate forum for redressal of his grievance, if so advised.
I will not kept as a part of the record.
The letter dated 29/8/2023 issued by the Deputy Commissioner of Police, Admin Guwahati, Assam, is made a part of the record and marked as Annexure X.
Acknowledgements.
This is the order, huh? Look. Okay. What is this?
Lordship, there are some queries and the finance department returned the same to the litigation department. We have made up the queries and it is sent to the finance department on 11.
You have sent it back.
Send it back, Lordship.
That means day before yesterday.
Yes, sir.
Okay. Okay, so we'll do. Yes, anything, madam?
Ask them to make this make payment on this year, Lordship.
Huh?
On this year, Lordship, ask them to make the payment.
In this financial year.
Oh,
Financial,
it should be done anyway. Look, right.
Lordship,
But-
financial year with March, Lordship.
Madam, please wait. There's certain things we actually, this is a contempt. We are acting like an executing court now, in fact. Be happy we're doing that.
10 years, Lordship.
Huh?
10 years pending case, Lordship.
So what to do? At least it's moving. Mr. N. Upadhyay, Learned Counsel for the Irrigation Department submits that the seal has been put on the proposal
Yes.
for sanction of the amount payable to the petitioner and sent back to the finance department for its approval on 11/12/2024. Mr. P. Nayak shall obtain instructions as to whether the proposal has been approved by the finance department. List the matter on if in the new year. Before bill, before bill.
Kindly bring the person after you, because I asked them, they said generally take 3 weeks, 3 weeks.
Okay, after bill. Two zero.
May please, your lordship. My lord, I have filed.
Which is the para? Which is the
Minor
para?
correction, your lordship.
Page
Page number 17, your lordship.
17.
Page number 17, the first para, the last line, your lordship.
Ah,
Application of the debt.
that ONGC, no?
By ONGC.
Okay, right.
With the petitioner.
So this heard Mr. N. Anik Singh,
Yes.
learned counsel for the applicant, who submits that a typographical error has occurred in the second last line of paragraph 6 of the judgment and order dated 29/10/2024, passed in WPC 210/2024. He submits that instead of the use of the word ONGC, inverted commas, ONGC, comma, the same should be petitioner. Pustak. Or petitioners. Petitioners. Petitioner. No, it will be petitioners.
Yes.
Petitioners. Pustak. Mr. B. Das, appearing for
Opposite parties, my lord. Both the opposite parties.
for
Opposite parties, my lord.
for the opposite parties.
Yes, my lord.
All of them. For all the opposite parties or for whom?
No, my lord, the spectrum, the petitioners, my lord. All two opposite parties.
For the writ petitioners.
Yes.
Petitioners.
For the writ petitioners, that opposite parties.
Yes.
Submit that he has got no objection to the correction of the mistake in the judgment and order passed in WPC 210/2020. Next, on perusing the order dated, judgment and order dated so and so, passed in WPC 210/2024, this court finds that a typographical error has occurred in the second last line of paragraph 6, comma, wherein the word ONGC has mistakenly been typed, comma, instead of the word petitioners. Accordingly, the word ONGC is to be replaced by the word petitioner. There. Full stop. Accordingly, the last sentence in paragraph 6 of the judgment and order dated 29/10/2024, passed in WPC 210/2024, shall be read as follows. He also submits that though, then, okay, instead of ONGC, you put petitioners. Yeah, page 17.
Right.
The I is accordingly allowed and disposed of. We're finished. We're finished. They're not here. Yes, okay. Where is the petitioner? Yes, Miss Mary, you have muted yourself.
Yes, my lord, I don't know, my learned friend, she's online, but I'll just inquire, my lord. With your permission, my lord.
Yes, yes. We have got. Okay, let's do that. We'll do some other matters then during that time. Okay.
Handling matters, item 3.
What is this?
Follow that matter where they were supposed to take an instruction. We were ready to give the money, my lord, which has been 25
Okay,
lakhs.
okay. Yes, Mr. Harsh Chaudhary.
I got the instruction. The department is of the view that this, otherwise the contract is not it's not a profit-making enterprise. Our goal was to distribute textbooks in time so that it reaches the children before the start of the academic year. Now, even if they give us the money, the department of the view that we have lost confidence on them, and we do not want to perhaps continue with a commercial relationship with them in the
That's
future.
why you don't have to continue. What I'm saying is let them pay the money and you let them participate in the tender.
Because participating in the tender, your lordship will again give them a right. We
Give them a right, but that doesn't mean that they have to be given. Since they have.
So the department is of the view that since we have already otherwise disposed of the representation.
Okay, then you want to have then what is to be done now?
Lordship may issue notice, but there is another problem with the matter. Again, this is also a matter filed by a company. There is no board resolution authorizing this person to institute proceedings on behalf of the company. So in view of the judgment in Kingston, perhaps without a board resolution, perhaps the matter cannot proceed further. And in the affidavit, he has just made a casual statement that he has been authorized. In the pleadings, there is nothing to that effect.
No, we can produce the board resolution. That's if they're
Sir,
questioning
because
the
that's-
maintainability.
Because now, your lordship, there are no materials to show that this person has executed the petition after being duly authorized by the company.
Now he's going to make it, his Saturday, Sunday is there, he's going to make it now.
No, he might, but because the board resolution otherwise has to precede the date of filing of the.
He'll make it.
It has to be certified by the company secretary also. So he can, it's otherwise a curable defect. I'm not on that.
Well, the
It's a
contract
defect.
which was executed with them at page 51. No, this is the same person, my lord.
No, that is a different matter. For instituting proceedings, the law is that to file a suit, there has to be a board resolution authorizing the person who has signed because he is exercising the.
Anyway, now the issue is with regard to the new tender that's going to
Yes,
be
Your
opened.
Lordship. If he participates, that will amount to setting at not the blacklisting order, and that means you get the final relief at the interim stage, Your Lordship. Because after all, the admitted position is that he has failed to deliver it. He has admitted. There is, and the purpose of this, I had a word with the managing director. I had a word with the managing director of the corporation. We are getting this money. So he said that the purpose of the contract is otherwise it's not a profit-making enterprise. It is that because the textbooks are supposed to be distributed for free. That amount of 28 lakhs is just the value of printing and paper what has been lost. But otherwise we distribute it for free. If once they fail to achieve the primary objective of the tender, then your lordship, we have definitely lost confidence in them that next year also same thing is good because these textbooks are meant for distribution amongst the poorest children, your lordship. And time, if they do not get it in time for the academic year, then everything is lost.
So what is to be done?
Lordship may issue notice, your lordship will file our affidavit and lordship may take up the entire matter for disposal.
But the blacklisting order, if it is not stayed, then I'm not able to participate. My lord, what is their intent of this order at page 91, my lord? They want to pick up this money.
I think maybe your senior might want to argue because you see the reason for the thing is that whether notice was issued to you, whether the intention, whether the issue of blacklisting was a part of the notice. If that was there, then what else remains?
My lord, the order at page 91, what they wanted to adjust the amount of money from my pending bills. Instead, my lord, I'm saying that instead of adjusting it, I'm ready to pay the entire money. Monday I'll be giving the money, my lord.
Why don't you allow them to adjust now?
No, no, because adjusting with my bills with incur me a expenditure with the GST also. But they want this money to be adjusted from my bills. It's the same money if I'm giving it in a demand draft to them. So the intention is to recover the loss.
Okay. The issues are threefold. Firstly, there is the issue of the pending bills. There is the issue of blacklisting, and then is the issue of forfeiture of the performance security. The issue of forfeiture of performance security, law is settled. Unless you can show irretrievable damage or fraud at the inception, your lordship, then there cannot be any case of injunction.
Okay, we will take up this matter when. We'll take up this matter when.
Lordship, otherwise issue, because the show cause is there. Lordship may have a look at the show cause. There it specifically says that failing a proper reply, we are going to invoke the power under clause so and so to blacklist you. Specifically says that our intention is to blacklist them.
Can it be on 17, madam? 20th is the last date for submission.
We can try 17, but it might be an uphill task. But we'll just say 17 only. On the prayer, the parties is the matter of 17.
Okay. Excuse me.
Yes.
Lordship, I have submitted my justification. Justification means justification.
You see, he has submitted two certificates. One is of 2014 and one is of 2017. So he has been having all this all along.
Lordship, the point is, once it is lapsed, can they register a new one with the same name? It is not permissible, first thing. The second thing, Lordship, they have the, once it comes into existence, it's a new entity.
No, no, it is Orient Society.
Name is same, but the registration is different. Number will be different, registration numbers. So that will be, identity will be different, Lord. They cannot have the same registration number. Renewal will give them same registration number. New registration.
No, no, they've got the same number.
For the new registration, Lordship.
It's not a new, it's just a
Lordship will see
continuation.
Lordship will see page number 198. That is the submitted document in the bill. I do not have the copy.
198.
I do not have the copy of the certificate they have given, Lordship.
198.
Lordship, the number will be, registration number will be shown there. I do not have the copy to compare. However,
Let me see 198. Yes, 198.
they have a registration number, Lordship. I do not have the copy to compare.
Okay, this.
It's 2120. That is a different registration number. It's not continuity, Lordship.
Yes. It's a different registration
Lordship,
number.
please come to paragraph, page 59, Lordship. Lordship will first see what is the requirement, Lordship. Page 59. Page 59. To qualify for award of the contract, bidders shall meet the following minimum qualifications. Lordship may come to B. The bidder must be a legal entity in existence for more than 3 years. It is not saying that it has to be a continuous or consecutive.
No, no. What he's saying is, this person is having a different number.
Lordship, because it was at the in the year 2021 it got lapsed. Thereafter the new amendment came, Lordship. So he was given renewal from the year 2021 when it got lapsed, Lordship.
How would they know that?
New
Without the
number is not the issue, Lordship.
How would they know that?
And
There is no
how we have justificated, Lordship. Lordship may kindly see my note,
If
Lordship.
you seek a clarification from them, that is not on record. They have clarified themselves not on record. This Lordship, and after the technical evaluation was carried out, we filed a writ petition, they came up with the explanation. That cannot be permitted in a tender
Lordship, may
process.
kindly see my
And why
justification, Lordship.
it may be favored, Lordship, after the tender was evaluated. There will be violative of Article 14, and it is arbitrary, Lord. The registration number itself says different identity. Name may be same.
Lordship, may kindly see my justification. One note has been given, Lordship. Lordship, may kindly see.
Is the justification just? That would be the question. There has
Lordship,
to
I'm
be-
starting from that small B, Lordship.
the bidder must be a legal entity in existence for more than 3 years. Now, Lordship may kindly see in this regard to prove the same, the bidder had submitted work orders, LOAs, employees, government department certificate issued in 2013, 14, 17, 19, 2020, and 2024. The certificate are genuine and verified and proves that the bidder is a legal entity and executed assignments and in existence for more than 3 years. Nowhere in the bid it is stated that such proof shall be sought only from incorporation, registration, society registration document. So it is not that it was renewed in the year 2021, that has to be counted from the year 2021 itself.
No, you see, we have to see
No, Lordship.
if whether that number has any
No,
significance.
Lordship will not
That is the identification.
justify of me being a legal entity only on the basis of the cooperative registration certificate.
What else is the document, Lordship?
No, you
My
see,
PAN card is there.
no, you see, not only that, we'll have to see, you see, a registration is only based on the certificate of registration issued by the, under this act. Now, supposing there are two entities, supposing there are two persons having the same name,
Lordship.
but they're having two different numbers.
It is a
Can-
subsequent renewal, Lordship.
It is
Subsequent
registration,
renewal,
not
but that is the name change.
And we'll have to see. You let him clarify that.
Lordship,
Let you
can come to
clarify.
page 49. I'll just point out.
Right?
Page 49. If tender permits the GMC authority to do so, what they have done.
Page 49.
49, Lordship. Clause number 30.3.
Yes.
A material deviation, reservation, or omission is one that, if accepted, shall affect in any substantial way the scope, quality, performance of the subject matter of procurement specified in the bidding document. Limit in any substantial way the inconsistent with bidding documents, rights of the employer or the obligation of the bidder under the prospect contract. B. If rectified, shall unfairly affect the competitive position of other bidders presenting responsive bids. That is, they are barred by themselves, Lordship. It will affect any competitive bidders because they are given an added advantage of submitting a document which is not 3 years.
Not
Anyway,
submitted, not new document. No new
It's a
document has been
replacement,
submitted.
Lordship.
Where is the
I'm-
new?
I'm saying-
let you
This
please,
document has
just
been
a minute,
Lordship.
please, you see, you have to enlighten me as to what would be the effect of having two registration numbers.
Same name, two different houses.
No. The registration, earlier registration of 2011-12, that no longer exists, Lordship. In the year 2021, it got lapsed. As per
You
the
see, one thing is, we'll have to see whether whether the new registration number what is the significance of having a new registration number? Would it mean that the earlier registration, would it be a distinct entity compared to the earlier registration number?
Lordship, may kindly explain me, Lordship. First registration, Lordship, 2011-12, it was valid up to 2014. Next registration was valid.
But
up to
both of them had the number, same number.
Yes, Lordship, same. Next one was up to 2017.
Yes,
Another registration was there up to 2021.
yes.
But that registration got lapsed, Lordship, in the year 2020.
Where is that registration?
Because during the existence.
Where is that registration that got lapsed?
What I am trying to emphasize, Lordship, and NGO certificate is not the only document, Lordship, on the basis of which we will determine his being a legal entity.
I'll check that. Let me see.
Other documents are also there.
You bring your 2017 to 21 registration. We'll see. I don't know. Let's see. Monday to no, I got too many matters. I'm back.
After vacation, it's there.
Huh? You bring it on Wednesday. Let's see if possible. Otherwise, we might adjourn the matter. You'll have to show me what is the effect of having two registration numbers.
What is the effect of registration
Yeah.
number under the society registration?
And please bring all the registration numbers. Please make this into an affidavit. On the prayer of the party, this is the matter on Wednesday.
Lordship, the interim arrangement.
Interim order to continue till the next day.
Like.
Yes.
My learned friend is
Please,
now
Your
online.
Lordship.
Yes, Shivya. Yes, tell me.
My Lord, this is a bail application filed by the applicant.
Yes, so
My Lord, the facts of the case is that. My Lord, the facts of the case is that the applicant was arrested by the excise personnel on 14 April 2023 for
how
alleged
many grams?
involvement
How
in
many grams?
connection with 90 grams of suspected heroin.
Ni-
90. 90.
90 is a small amount or a big amount or what is it?
My Lord, it's a intermediary below commercial
Okay, that much I know.
quantity, but
Commercial
above
is
small
250.
quantity. Yes, my Lord.
So 90 grams.
And he was
90 grams was seized from this person, Zaire Ikuma, from the present
yes,
petitioner. Is it?
yes, my Lord.
How many
Yes,
accused
yes,
are
my
there
Lord.
in this case?
And along with him, yes, my Lord. Along with him, pardon me, my Lord.
How many accused are there in this case?
There are 4 accused.
4 accused. Okay.
All the other
So
co-accused are out on bail now.
are out on bail.
And my Lord, your Lordship, yes, my Lord, has been granted bail. 2 has been granted bail by the district court, by the trial court, and 1 is granted by your Lordship.
Okay. Yes. Okay. So only he remains. Madam, PP, additional PP. So
Yes,
3
only
out
he
of the 4
remains.
are already on bail. What to do?
My lord, stringent condition may be imposed on the uh, present accused because he's not a resident of India. He's
He's
a
not.
Myanmaris, yes, my lord.
So he'll run away, madam. If he runs away, then what to do?
That's why it's better that he's in custody, my lord.
No, my Lord. My
Huh?
Lord, he hails from Myanmar. He hails from Myanmar. However, he has relocated in Edzokuttar now. He's been living there.
So what?
Illegally, my
Then
lord.
we can have a.
He's an illegal immigrant. Okay, tell me one
No, my
thing.
Lord.
Hmm.
He has been living there for about 5 years.
Maybe. Burma is having problems. They'll all come here. Now, okay. So what is the stage of the trial?
3.
And there are 9 prosecution witnesses, and only one has been has appeared before the learned trial court.
When was he arrested?
So the witnesses are also not turned. He was arrested on 14 April 2023.
14th April 23.
In one,
That means
my lord, it's been 1 year and 8
he's been
and within
1 year, 8 months he's in jail. That means. Okay.
yes, my lord. And only one prosecution witnesses have
How much? How much bond? How much bond? 2 lakhs.
turned up. And
2
the trial
lakhs
is
with
going very
2 sureties of like amount.
uh
Has he got some other case?
no, my lord, this is
First time.
no. This is the only case. He's a first time offender.
So how much
My
should
lord,
be the
if
bond?
it's not a commercial quantity, if the bone
No, I'm not.
maybe, my
I'm asking
lord,
the PP.
if your lordship permits 50,000.
No, 50,000 too less.
Sorry, I
My lord,
apologize.
I do not know about. I do not have any opinion about the amount. But then, if the surety be a government servant, not below the Yes, government servant, my lord.
Whether it's a government servant or not, doesn't matter. They'll give them the money.
But then at least
Then,
they
then
will
if they
be,
run away, then that's why I'm saying the amount of money that they lose, that is the issue.
my lord, I was under the impression that if they are a government servant, then they will have the knowledge that if they run away, then they will be in trouble.
No,
So
they will not be in trouble. These persons will give them the money and then they'll run away. That's why they should not give too less of money. If there's more money involved, they won't run away.
2 lakhs, my lord.
I think so. This one is, I think he's the main person.
The main person in this case,
No, my lord.
Huh?
No, my lord, it is seized from his possession. However, he's not the main case. He's not the main guy
it was
because
only
it
from
was
his
sponsored by.
discovery. Yes, sorry.
Yes. That's why if he was the main guy, then he wouldn't have stayed in jail for so long, my lord. He wouldn't have lingered so long. And it's not even a commercial contract.
My lord, it is from his disclosure statement only that other accused
Yeah, okay. Right.
apprehended.
So actually 90 grams plus another 14 grams was seized, I think. He has not told me the entire
Yes, 14.
story.
My lord, 14 grams was seized from Mal Somzwala, who is the co-accused.
Okay, okay, right. Heard Miss Sakis Fanai, learned counsel for the petitioner. Also heard Mrs. Mary L. Kente, additional PP. This bail petition has been submitted by the accused petitioner Zairikuma, Zairikuma, in connection with the seizure of 90 grams of heroin from the petitioner on 14/4/2023. Correct? Is it date of
Yes, my
seizure?
lord.
14/4/2023.
Yes, my lord, 14 for
The
2023.
petitioner was also arrested on 14/4/2023. Next para. The petitioner's counsel submits that besides Zaire Kuma, there were 3 other co-accused, one of them being Mal Somzwala, MALSAWMZUALA, from whom 14 grams of heroin were seized. The petitioner has been in jail since 14/4/2023. While all the other 3 co-accused have been released on bail. Next para, the petitioner's counsel submits that out of the 9 prosecution witnesses cited by the IO in the charge sheet, only 1 prosecution witness has been examined till date. The petitioner's counsel submits that in view of the petitioner being in jail for around 1 year, 8 months, and as the trial of the case has only just started, the petitioner should be released on bail. Mrs. Mary L. Kente, the additional PP, on the other hand, submits that the petitioner is a Myanmarese national, and unless stringent terms are provided in the bail condition, the petitioner would abscond. Full stop. Anything else, madam?
That
Your-
that's the accused, the accused applicant is the main perpetrator of the instant case.
full stop. Further, the petitioner is the main accused in the case. Full stop. Next, I have heard the learned causes for the parties. Then, in the case of so-and-so versus so-and-so, right, the Supreme Court has held that. This is with regard to, you see, long incarceration of jail, where court has said that even section 37 would not apply, even in a commercial quantity case. So, with so, then you say, then various things, and further, next paragraph, this further, in view of the fact that all the three co-accused have been released on bail, and as the trial has only just started, the petitioner should be released on bail. However, keeping in view the fact that the petitioner belongs to, belongs, petitioner's nationality is Myanmarese, a strict condition for release on bail should be imposed by this court. Accordingly, bail is granted to the petitioner on a bail bond of rupees 2 lakhs with one surety of like amount to the satisfaction of the learned trial court. First off, the petitioner should not leave the state of Mizoram without the prior permission of the court, and he should not attempt to interact, should not make, attempt to interact with the prosecution witnesses or hamper the, or tamper with the evidence. First off, violation of any of the above terms will entail automatic cancellation of the bail. The petition is accordingly disposed of. Okay.
Deeply obliged, my lord.
Deeply obliged.